Thank you.
Recording has started.
Thank you. Good evening. This is the February 2024 regular meeting of the Complaint Committee of the Sunshine Ordinance Task Force of the City and County of San Francisco. The time is 5:30 p.m. The Sunshine Ordinance Task Force and its committees convene in hybrid meetings that allow for either in-person attendance or remote participation. Public comment will be taken on each item of the agenda. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Chair Schmidt, that completes my announcements.
Thank you. Let's go ahead, start with number one today.
Item 1, call to order, roll call, and agenda changes. We have no known changes.
Okay. There's one item that I wanted to see if there's a reason that we should wait until the end of the calendar, which is one that there was a stipulation on where let's see, I think it was the Fine Arts Museum. Basically, I'm not going to say pled no contest, but they admitted no contest. And so I would think that under our rules, we will be putting that on the consent calendar. I asked the members, would you think that we should just do that right up front, or should we just wait till number 6? It doesn't really matter to me, but since it's consented to, I know there's another matter with the same parties, so maybe it doesn't matter this time. Any thoughts on that?
Well, my only thought would be if we move it up, then it's out of the way. If there are certain people who are not able to kind of come to the hearing until 6, people who are working, and so it shortens like how long they have to wait for things. So I guess I would maybe say move it up if we want to go ahead and do it.
Okay, so let's move. Let's see, that is number 9. Let's hear that first among the complaints. So that will go just ahead of number 4, and we'll deal with it very quickly. Nothing else on item 1. Just that one change.
I'm repeating back. Item 9, file number 24003, complaint filed by Anonymous against the Fine Arts Museum, has been moved to the top of the agenda in front of item 4. Item 4 is file number 23095, complaint by Mark LaCroix against the San Francisco Fire Commission. Correct?
Yes.
Thank you.
So I'd say we can call the roll then.
Roll call. Member Stein?
Here.
Member Stein, aye. Member Sugarman?
Present.
Member Sugarman, aye.
Oh, aye.
Chair Schmidt?
Present.
Chair Schmidt, aye. We have a quorum.
Oh. Okay, number 2.
We have a hand raised for public comment right now. I'm not sure if they want to comment on the item 1 or not.
Since we made an agenda change, I'll allow it if they do.
Okay, I'm going to go ahead and unmute them right now. Caller, you have been unmuted. Would you like to make public comment on item number 1?
Yes, I would, Victor.
Okay, at your discretion, Ms. Peterson. Do you have the clock ready? The timer?
I am ready. Ms.
Okay.
Trudeau, are you ready?
I'm ready.
Your time begins now.
Ann Trudeau here. Thank you for moving that up because for me it's a time difference. It's 3 o'clock in the morning, and that was a case that interests me a lot. And I think, yeah, it's a good thing that you moved it up. That's it.
Thank you.
Thank you.
I have no additional hands raised.
Okay, number 2.
Item 2, approval of the January 16, 2023 Complaint Committee meeting minutes.
Okay, members, any comments or changes?
Yeah.
Yes, Member Stein.
Okay, so on page 3, paragraph 6. Which is the paragraph that is the action, the bolded paragraph. I think what we had in the original thing was a consideration of whether it's a provision for timely complete records violations. Oh, wait, oh, we do have that, or a violation. Okay, never mind, that is in there. Sorry, I didn't see that the first time around, so that looks good. But then I did have another one on page 5, item 6, under the action, bolded paragraph again. I had and I guess I want to check this against other people's memory, that we had also added potentially considering failing to send an authorized representative to the hearing. But I don't know if anyone else remembers that. If it was not an authorized representative.
Who was the agency?
In the Chief Medical Examiner office.
I don't have a specific enough recall on that one.
Oh, it says right there, Office of Medical Examiner was not present and did not notify the SOTF.
Oh, okay, okay.
I saw that there. So that was in the notes. So I think we did talk about considering a 6721E for failing to send an authorized representative to a hearing.
Yeah, now that you mentioned that they just weren't here, I do recall that I believe we did add that into the decision.
It was in my notes, but that's not always but I think we did.
Where should the language be added in the bolded language as it appears?
And just at the very end, I would just say after, whether there are any alleged violations, I would just say as well as failing to send an authorized representative to the hearing. And in parentheses, 67.21E.
Item 6, adding to the action item at the very end of the statement, after whether there are any of the alleged violations, comma, as well as failing to send an authorized representative to the hearing, parentheses, 67.21 sub E, close paren period.
Yeah, and that's my only correction.
All right, I'll certainly not object to any of those changes myself. Member Sugarman, I think maybe you weren't at the meeting, but do you have any edits on it?
I do not. Thank you, though.
All right. In that case, I would move that with the edits from Member Stein, that we approve the minutes.
And a second, please.
I'll second it.
Seconded by Member Stein. Public comment?
Yes.
Any members of the public who would like to make public comment, you can approach the podium at this time. And if you're joining us remotely, you can use *3 on the telephone to raise your hand, or otherwise use the application to raise your hand at this time.
There is no one present approaching the
see.
podium.
I see no hands raised at this time.
Let's vote.
Taking the vote, Member Stein?
Aye.
Member Stein, aye. Member Sugarman?
Aye.
Member Sugarman, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. 3 ayes. The motion passes. Item 3.
Yes, please.
Item 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda. If there's any members of the public in the room who would like to speak on this item, please approach the podium. If you are a member of the online community and you would like to speak, please raise your hand pressing *3 or using your app, raise your hand. We have no one in the room. We have one caller online.
That one caller has been unmuted at your discretion, Pat.
Sorry, Victor.
That's all yours. You take control.
Thank you. Hello, caller. Would you like to speak on item 3?
Yes, I would.
One moment, please. Your time begins now.
I just want to make a comment that I hope that this committee stays on track and focuses on the Sunshine Ordinance and any potential violations of it. In a case that I had that really wasn't finished, it was a little frustrating for me because the issue was the Sunshine Ordinance and violations. I just want to add that now the case is finished. The documents that I got from the city attorney's office were not complete at all. And I fully expected these documents that I got to be not consistent with the documents that were filed with the California Court of Appeal. A number of them that I received from the city attorney's office did not have the court stamps on it. That means that they were not public documents and they were not entered into the California Court of Appeal system. So I just hope that when this case reaches the Compliance and Amendments Committee, we can have a discussion on what exactly is a public document and what isn't, because that's been a problem of the city attorney's office for a long time. That's it. Thank you.
Thank you.
Okay, next item.
Item 4, file number 23095, complaint filed by Mark LaCroix against the San Francisco Fire
Pat,
Commission.
I think you got to jump to 9.
Yeah, number 9. This
Thank you.
proceeds.
Item 9, file number 24003, complaint filed by Anonymous ACU against the Fine Arts Museum for allegedly violating Administrative Code, Sunshine Ordinance, Section 67.5 sub B, as in boy, by failing to make meetings of this policy body open and public and governed by the provisions of the Ralph M. Brown Act. Section 67.16, by failing to provide meeting minutes within 10 working days after the meeting.
All right, this is a matter where I see in the record at page 106, and I know there's another reference also in the record, that the responding agency is declaring no contest to the allegations. So I believe it's appropriate that we send it onto the consent calendar. It does need to be given a final decision, not by us, but by the full task force. And so I think that, and I appreciate the clearing of the no contest. I'll just go ahead and make the motion that we find, in accordance with the no contest declaration, that there were violations as alleged, and that this be placed on the next available consent calendar.
Chair Schmidt, can we list the violations that they acknowledge?
That's fine. I believe it's 67.5B and 67.16.
Okay, just as listed in the title. Thank you.
Yeah, exactly.
I just wanted to be in the actions, so when it goes on the consent, it's clear what they are approving.
Absolutely. Thank you. Thank you, Victor.
I may be asking you to repeat that motion, please,
Sure.
in full.
The motion was based on the declaration of no contest of the respondent. Move to find violations listed in the petition, which are section 67.5B and 67.16, and this be placed on the consent calendar for the next task force hearing.
Meeting based on the declaration of no contest of the respondent, move to find violations listed in the petition, which are 67.5B and 67.16, and that this be placed on the consent calendar for the next task force meeting. That will be March 6th.
We're not going to state the meeting.
Date,
That's up to the chair of the full task force to decide what meeting it'll go on.
repeating back, will be placed on the consent calendar for the next task force meeting.
Next available task force meeting.
And will be placed on the consent calendar for the next available task force meeting. And moved by Chair Schmitz, seconded by
Seconded.
Member Sugarman.
If there's anybody who'd like to make public comment on this motion, You can approach the podium at this time or otherwise use the application to raise your hand. If you're on the phone, you can press *3 to raise your hand. I have one person with a hand raised. I defer to Ms. Peterson.
We have one speaker in the room, Chair Schmidt.
I don't think the order matters. Let's go ahead and hear from our person who is present here.
I'm the complainant, and I did have an additional question. I don't know if I'm entitled to ask that right now, but this complaint. Just a moment, please. Question or start the timer, please.
I'll allow it since it's not a procedure that we see that often. So go ahead.
That was my issue, is that this circumstance.
Can I pause for a second? Can you make sure her microphone's on?
You might have to.
Microphone appears on. Could you speak into the microphone?
Sure.
one
Is
more
that
time
better?
for me?
Yes.
That's better.
Thank you.
That's better.
Yeah, I just wanted to make a comment that this issue that was the basis of this complaint made it a little challenging to identify all the violations in the Sunshine Ordinance, because it was a meeting that was simply not noticed, agendized, no minutes provided whatsoever. And additionally, I just would maybe what I'd like to ask is if I need to file a separate complaint regarding potential violation of the California Government Code, Section 54959, which holds that each member of a legislative body who attends a meeting of that legislative body where action is taken in violation of any provision of this chapter, and where the member intends to deprive the public of information to which the member knows or has reason to know the public is entitled under this chapter, is guilty of a misdemeanor. The equivalent Sunshine Ordinance section only addresses specific individuals. As far as I can tell, the California Government Code, this would apply to members of the Board of Trustees. And given that a nearly identical resolution had been issued at a properly noticed meeting on June 1st, and then 3 weeks later, the resolution in question was produced, indicates to me the intent covered by Section 54959.
The place where we're at is that we have received the specific intentions that were placed before us, and the respondent had a chance to review those, and with only those in the record, the respondent is stating no contest. If you wanted to add something further, I think that you probably would want to do that separately, especially if it's a provision that refers to criminal law misdemeanors. And I'm not trying to discourage you from doing it, but I would say you probably should do that separately. Members, any?
Yeah, I mean, I would say the same thing because they're not saying no contest to
Okay.
that
Yes.
issue. And
Okay.
so we can't really forward on.
Yeah,
the
that's
basis
fine.
of that.
I just wanted to double check. And I just wanted to reiterate, I had already provided an email regarding this, but as support for the complaint, I am including the formal response from the Fine Arts Museum to the complaint. In the memo they provided in their response on page 3, they write, "This matter concerns a clerical and procedural error. Upon further investigation of anonymous complaint, FAMSF discovered multiple errors regarding Board Resolution 1828. Yet in their response, they never identify these errors." And I wanted to point out that.
Yeah, I think we've
Seen that? Okay.
reviewed
Okay,
everything, and I think this one was clear that it should go to our consent calendar where we will briefly consider it, and there's a good chance you'll get an order in your favor
Okay.
on that. Yeah,
thank you.
so we'll leave it at that, unless well, if you're a party to the matter, then we can't let you make public comment on it.
That's fine. That's fine.
Yeah.
And I just want to make sure I didn't miss the other complaint.
There's another complaint that is It's, there's an 02 and an 03. The other one will be the 6th item, and this is the first item on the calendar.
Which is why it's coming out of order.
Yeah. Okay, the other public commenter who's online.
We don't need a motion first.
We have a pending motion, but there was a person in the room for public comment, and then there was also someone online to give public comment, and so it's now their turn.
Thank you for the clarification.
Sure.
Members
You've
of
been
this
unmuted.
members of this committee, Ann Trabell. This
One
is,
moment, please. Let me start the timer.
Oh, okay.
Please begin.
Ann Trabell. I remember up to, could be 6 years ago, I had similar complaints with the Fine Arts Museum over almost this identical issue. They didn't say no contest. There were hearings, and it went to the full task force. But it just, a little shocking to me, so many years later, it could be 6 or 7 years later, that the same names that I saw on the emails of the documents, Megan Bourne being one of them, she did appear, but they never changed the way they did things. And it's a little unsettling for me to hear the same allegations being made 6 or 7 years later. And I think it's a little too easy for them to say no contest so they don't have to have a hearing. That's it. That's mine. I'm finished.
Thank you.
All right, let's vote.
Taking the vote. Member Stein?
Aye.
Member Sugarman?
Aye.
Chair Schmidt?
Aye.
3 ayes. The motion passes. Returning to item 4. File number 23095. Complaint filed by Mark LaCroix against the San Francisco Fire Commission for allegedly violating Administrative Code Sunshine Ordinance Section 67.10 sub B by failing to consider the appointment, employment, evaluation of performance, or dismissal of a city employee. If the policy body has the authority to appoint, employ, or dismiss the employee, or to hear the complaints or charge brought against the employee by another person or employee, unless the employee complained of requests a public hearing. Respond to a public records request in a timely and or complete manner, 67.11. Prior to any closed session, a policy body may state the general reason or reasons for the closed session and shall cite the statutory authority, including the specific section and subdivision or other legal authority under which the session is being held. 67.12, by failing to disclose closed session discussion and actions.
All right, so we are going to have probably 5 complaints or petitions, as I prefer to call them. Same synonyms. The process that we're going to take today, I believe that 3 of these involve public meetings issues, and 2 of them involve documents issues. Although that's, we hear each. Those are both part of our ambit. The process will be as follows. We will allow the petitioner to speak, and followed by the respondent, up to 3 minutes each. with in mind, knowing that we have already had a chance to read the written record, so we already know what the cases are about. Following that, the members may have questions for the parties, for anyone who's a witness, and after that, when questions are over, the task force, the committee will decide what to do next with your matter. In many cases, we will send a matter on to the full task force for a hearing and a determination. We can't make any final decisions here under our current rules. A couple of questions that we're tasked to look at are whether the task force has jurisdiction, whether the case involves public documents, public meetings. We may make a recommendation, and I think that's basically how the process is going to work here today. So I'll ask first, is Mr. LaCroix online?
Yes, I am.
Okay, great.
Great.
And we have someone from the Fire Commission.
We have Maureen Conifrey.
Great, okay.
May I check? We have one caller online. May I see if they're a party?
Sure.
Thank you. Hello, caller. Are you a party to this item or are you awaiting public comment?
I'm making public comment.
All right, I am muting you. Thank you.
So we will hear now first from the petitioner, Mr. LaCroix.
Thank you, Chair Schmidt.
1 moment, please.
Standing
3
by.
minutes, Chair?
Yeah.
All right, your 3 minutes begins now.
Thank you. Good evening. The Fire Commission held a special meeting on April 6, 2022 to address a motion to dismiss charges that I had filed and was able to successfully argue on that day. The Fire Commission voted to go into closed session to deliberate on the matter. I had notified the commissioners before the closed session that they had improperly noticed the agenda for a closed session to take place. The Commission now admits in their reply to the task force that they a violation of 6711 by failing to cite the statutory authority, including the specific section and subdivision or other legal authority under which the session was being held. The Fire Commission contends now that a closed session was proper under the Sunshine Ordinance, Section 6710B, closed session permitted topics. If we strip down the pertinent keywords in that section, we can condense it down to consider the dismissal of a city employee if the policy body has the authority to dismiss the employee. The Fire Commission's deliberations in this matter were not to consider my dismissal. They were to consider a motion challenging the validity of dismissal charges. A simple review of the agenda and minutes of the meeting will reveal these facts. Also, dismissal was not in jeopardy at this meeting. Since it was not noticed as a separation hearing, the Fire Commission has formal procedures for dismissals, which had not taken place, so the Commission had no such authority to dismiss me at this meeting. Hence, the deliberations of the matter fail both elements of 6710B in that they were not considering dismissal, nor did they have the authority to dismiss me at that meeting. The Fire Commission is also asking for a broad interpretation of this section, and that because a topic pertains to dismissals, it should be allowed to be discussed in closed session. Problem with that argument is that not only the Sunshine Ordinance, but also the Brown Act and Section 3B, Paragraph 2 of the California Constitution state that these rules are specifically required to be interpreted narrowly. The California Constitution states that a statute, court rule, or other authority shall be broadly construed if it furthers the people's right of access and narrowly construed if it limits the rights of access. Similar text is in the Brown Act and the Sunshine Ordinance. Pertaining to dismissal is not considering dismissal as 6710 reads. I ask that you recommend a violation of the Sunshine Ordinance open meeting sections as appropriate and request that the record be made public and released to me upon determination by the full task force. Thank you. And of note, 6712 was never in my complaint. I don't know how that ever got into the complaint, but 6712 is never in contention here. Thank you.
Okay, thank you.
We have Maureen Conifrey.
Yeah, let's go ahead with the respondent.
Who's
Okay,
Conifrey?
Hi, it's Maureen, Fire Commission Secretary. Good evening to Chair Schmidt, Member Stein, Member Sugarman, Mark, good evening, Pat and Victor. Somebody is in the meeting, caller user 808, and I don't know why they're in our meeting. It should be an attendee. And they're making lots of noises.
One moment, please.
Okay, they seem to be gone.
Okay, we could continue.
Okay.
Are you ready?
So, yes,
Start the timer.
on October 23rd, 2023, Mark LaCroix sent a public record request to the Fire Commission stating that he wanted the closed session, either audio or transcript of a meeting that was actually, he wanted the closed session portion of it because the hearing was actually held in open session. And we voted to go into closed session to deliberate. And on 10/27, I responded to his public records request, denying his request, stating that it was against the law to provide closed session deliberations, and that we did announce in open session the outcome of the closed session deliberations. Mr. LaCroix then filed a complaint with the Sunshine Ordinance Task Force. We were asked to submit a history of the records request, which I did on November 21st, and we stand by the response to that letter.
Thank you.
And that is, yep, and that is my response.
All right. So at this point, we may have questions for the parties. Members, do you have anything at this point for either party? I'll ask Mr. LaCroix. You claimed that there was improper notice of the fact that they wanted to deliberate in closed session. Could you clarify? You may have said it, but I want to just make sure I hear it. What was the kind of notice, and at what point in time was the notice not properly given?
Okay, Mr. Chair, Mr. Schmidt. The notice, I don't have the agenda right in front of me right here, but it didn't cite the statutory authority or the section of the Brown Act or Sunshine Ordinance as they normally do for a closed session. So it didn't say that they were using 6710 of the Sunshine Ordinance B.
When you say it didn't say, are you talking about the agenda?
Yes, I apologize. The agenda did not state the statutory authority or the section that they were going into closed session under. So I brought this to their attention when I believe it was right after they voted, or actually it was before they voted. I said that it wasn't in the agenda as properly noticed, and Commissioner Feinstein assured me that everything was proper. And so then they went ahead and went into closed session.
Okay.
They have since, in the reply letter, if you noticed, they admitted that they did violate Section 6711, which is the notice or the statute that describes the statutory authority that they must cite in the agenda.
Okay. What page in our record is that admission?
Are you asking me, sir?
Yeah. Can you point to
I can.
where? Oh, you can. Okay.
Yes, it's page 21.
21. Thank you.
And it's under section 2, the very last. There is no need for a hearing on this issue as the commission acknowledges a technical error here that it will avoid in the future.
Great. Appreciate the clarity on that. We have a question from Member Stein.
Yeah, this is a question for the petitioner. So I think you have referenced that you requested that the hearing be public. When did you make the request for the agenda item to be public?
I believe that was October. Ms. Conifrey kindly stated the date in her reply.
So that was like you submitted something in writing asking that it be.
Yes, that should be in your packet there.
I did not see it. So, and I was kind of looking for it, but I maybe I missed it. And on what basis were you requesting that the hearing be public?
Oh, so in my letter to the commission for the public records request, I cited that it was an improper topic. It was not a permitted topic for a closed session. And that's because deliberations, while in a separation hearing, when separation is at stake, which they call dismissal in the Sunshine Ordinance, deliberations are permitted under the Brown Act, or they're spelled out in the Brown Act that closed session deliberations and dismissals are permitted. However, this was not a dismissal hearing. This was on a motion to dismiss. And just so maybe you understand a little better, the fire department filed incorrect charges against me, and I spent 5.5 months under suspension awaiting a hearing to have the charges dismissed. And in this closed session, while it's important to me, is the Fire Commission elected not to exercise their ministerial duty to award remedy in the case. So, and then they've never explained why. And it's basically cost me $82,000 of back pay. And since I've been separated, basically about $230 a month for the rest of my life. So this closed session is which I contend is not a permitted topic, is where these decisions took place. And I've been seeking an answer to why they wouldn't provide remedy ever since, and they won't provide one. So this is my administrative course of action to try and reveal what's going on with the Fire Commission and why they won't reveal answers to me.
Okay, thank you. And I have a question too for the Fire Commission, which is, do you have anything written down in your own internal policy about that would shed light on why you consider any hearing pertaining to a dismissal to be to fall under 67.10B to actually be a vote on dismissal or?
Okay, so that actually is incorrect. Like I said, the hearing was in open session at the request of Mr. LaCroix. So the whole hearing was open. He received the WebEx tape of that. It was when it was time for the commissioners to make a determination, and the hearing was strictly on his motion to dismiss. It had nothing to do with back pay. It was strictly as the agenda stated. The commission will consider a pre-hearing dispositive motion on an employee dismissal case. The commission went in They voted, although the statutory sites were not on the agenda, there was on the agenda whether to conduct deliberations in closed session. It was an action item, and they voted 2-1 to go into closed session, which we did. We came out of closed session, announced in open session what the outcome was in favor of Mr. LaCroix, and I took a vote on to elect whether to disclose any or all discussions held in closed session as specified in San Francisco Administrative Code, Section 67.12A, and it was a unanimous not to disclose.
Yeah, I understood that actually. Sorry for reading the packet. Maybe I didn't state things or state my question as well as I could have. I guess I'm just trying, I feel like the point of difference here is that you are arguing that anything that relates to an employee's potential or a potential action for dismissal of an employee, even if it's a pre-motion about that, falls under 6710B, whereas the petitioner is saying it doesn't. And so I just wondered if you had any kind of internal policy like that, any, written down anywhere about what would constitute a sort of hearing on employment to consider someone's employment, if that's everything to do with it, or if that needs to be more narrowly construed to, determining whether or not you were going to dismiss somebody.
Yeah, we would not do deliberations in open session if it constituted dismissal of an employee. I think that's against the law.
No, that is clearly
An
against the
open
law,
session. It's a personnel matter.
All right, I'm going to leave it there.
Okay.
Okay, we have now a question from Member Sugarman, but Member Sugarman, let me just say that I just want to clarify, because I see these things maybe more than the average person. We're actually talking about two uses of the same word, the dismissal of the employee versus the dismissal of the case seeking to dismiss the employee. And so let me just put that out there. Just it can be confusing. I'm sure everyone understood that. Okay, Member Sugarman.
Thank you. I have an obvious question, honestly, which is I understand that the disclosure, or at least as it's put forward, was not properly put into the complaint or the agenda in terms of why the commission went into closed session. My question is for either party present is, again, this is obvious, but did the commission disclose verbally why they were going into closed session? Was there a disclosure made?
Just to deliberate on the open session hearing.
Yeah, but I mean at the time that it happened, was it announced that you were going into closed session for a certain reason?
To deliberate on the open session hearing.
Okay, thank you.
Okay. I think that I don't have anything further. I think I know enough for purposes of what we're doing here today. It does sound like there's one item where there has been a concession, and yet there are other items that we might want to be sending on to the task force to look at. Members, any thoughts on what to do with this matter? Should we send it to the task force? And if we should, how?
Yeah, I mean, I would make a motion to say that these are public records under our jurisdiction, or it's a public meeting under our jurisdiction. Send it to the task force with a recommendation that they find a 67.11 violation, because that's already been acknowledged, and consideration only of whether there might be a 67.10B violation.
And just to clarify, and this is not part of the motion, the second part is not part of the recommendation.
No, it's just to consider.
It's to consider.
That's what is the focus, to consider whether there's a 6710B violation. And of course, I'm just leaving off 67.12 since the petitioner has said that is not part of their complaint. And it doesn't seem to have been violated in any case.
Yeah. Okay. Yeah. I tend to think that even if it was technically a motion to dismiss the dismissal action, I think that the content of what was being considered is probably, well, I'm getting a little ahead of us here, but I think you could argue that it was the equivalent of what a dismissal hearing of the employment matter would look like. So that would be what's important to me. Okay. Member Sugarman, would you like to second the motion, I should say? Or should I? Any comments? Or do you have any or do you have any other thoughts that you think we should be considering here?
Excuse me, I come at this with a limited amount of understanding of this specific, but my question is, it seems when you're talking about buying in 6711 and 6712 talks about disclosure of the reason for the closed session. And while it wasn't on the agenda, what I just heard was the reason was apparent why they went into a closed session.
It was on the agenda. What wasn't on the agenda was a reference to a particular citation, but they did give verbal sort of rationale in the agenda why it was a closed session.
So, and what I'm hearing you say is still that this should be a matter of public record, right?
We're saying, I think that I'm saying that the task force can consider that question, whether or not this was a properly a closed a topic that a closed session could apply to.
Okay.
May I get clarification on the motion? So what I heard was that these are items under the jurisdiction of the Sunshine Ordinance Task Force, that they are public documents. Section 67.11 is acknowledged, the violation, and the question is whether to forward for consideration of whether there is a violation of 6710B.
Yes, but we don't have a second technically, so it may just die as a question.
Okay.
Ms. Peterson, instead of records, could you say meetings?
Oh, sorry, yeah,
think
public
Member
meetings.
Stein had
Yeah, public
made that
meeting.
alteration.
You made that motion.
Yes.
And so what do you think then?
I was just mainly making somewhat of a observation. Her motion is still alive, but I just wanted to make the observation that what they were deliberating on in closed session and what had been open in the hearing, even though it was technically in the context of a motion to dismiss, the potential effort to dismiss Mr. LaCroix as an employee, I think that the substance of what was both considered at the hearing and was deliberated over was the same kind of substance that would be involved in a disciplinary or employment type of situation where you would obviously deliberate in closed session.
I agree with that.
Okay. Okay. So I would tend to, I wanted to see, because I'm not opposed to Member Stein's motion, but I wanted to give you a chance to air, anything you wanted to talk about here, or to second the motion.
Yeah, I would just elaborate that I understand like the content of the complaint, that it's not directly, and what you had said about how it's not directly a dismissal matter. Like I understood that from when you said it, but also in the context of when Mr. LaCour was speaking about it. And to me, it still seems like an employment matter as so discussed under the Sunshine Ordinance, personally.
Okay. Well, I think that I'm going to second that. It's a good motion. So we're ready for public comment.
Are there any speakers in the room who would like to provide public comment? And if yes, please approach the podium. We do have one speaker in the queue with their hand raised. No one is approaching the podium. Would you like the online caller?
Yes, please.
Hello, caller. You've been unmuted. Hello, caller. Would you like to make a comment on item 4?
Yes, please.
One moment, please. Would you state your name for the record?
No, I'm public comment. I don't believe the public has to identify themselves in a public comment.
That's fine. Would you like to begin?
Yes, thank you, Task Force, for tonight. I just wanted to say that there has been some serious lack of transparency coming from the San Francisco Fire Commission and the collaboration with the City Attorney's Office. I urge you to take a genuine interest in investigating, because there's been a disservice to the public and the taxpayers and the members of the San Francisco Fire Department. And in agreement with one of the previous public commenters, it seems it's very easy for the city to hide behind all these quote unquote private meetings they do in the back, regardless of what they're saying it's for or not saying it's for. So I implore you to please investigate and genuinely take a good look at what Mark LaCroix is saying. Thank you.
Thank you.
Thank you.
All right, let's vote.
Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Stein.
Aye.
Member Stein, aye. 3 ayes. The motion passes.
Okay, next matter.
Item 5, filed number 23099, complaint filed by Mark LaCroix against the San Francisco Fire Commission for allegedly violating Administrative Code Sunshine Ordinance 67.5 by failing to conduct meetings of any policy body open in public. 6710, conducting a closed session hearing on a non-permitted topic. And 6711, by failing to properly notice a closed session hearing.
All right, the first thing I'm going to do here is ask the members, did you see anything here that is a substantive difference with the last case that we heard? It seems like maybe we have duplication. Did you get a sense of that, or did you see something that you believe merits these two cases being separate?
Okay, I might have have this wrong in my notes, but I thought it was a different request for a different closed session hearing. I thought one of them referred to one, the first one was asking for info about, where did it go? And I could be wrong on that. Case heard on 4/6/22 in the first one, the petitioner's request was for that. And in the second one, it was request for a hearing heard on, that happened on 1/12/22.
Okay. That's my oversight then. In that case, we have the claims may be just about the same, but we're talking about two different, very similar situations. Okay. In that case, we're going to keep the cases together throughout, but since they involve the same parties, very similar claims. When Ms. Peterson is ready, we will start with Mr. LaCroix for up to 3 minutes.
Mr. LaCroix, are you still with us?
I am.
All right. Are you ready to begin?
I am. Thank you.
Your time begins now.
Okay, this one will go a little faster. So the Fire Commission held a closed session meeting on January 12, 2022, noticed as follows. Personnel exception, status and calendaring of pending, disciplinary, and separation cases. Status and calendaring of pending, disciplinary, and separation cases appears to be purely administrative acts and not a permitted topic for closed session under the Notice Sunshine Ordinance Code 67.10b. The Fire Commission's response to my request stated that the closed session that I seek, quote, pertained to the potential dismissal and separation of employees, unquote. Pertaining to dismissal, once again, is not considering dismissal. According to Bollinger versus San Diego Civil Service Commission, which the Fire Commission put forth in the last case in the reply, considering it, the court explains in this case, considering is deliberating. And if the Fire Commission was actually considering my dismissal, as they state in the response letter several times, the meeting should have been noticed as a separation hearing. Status and calendaring to a person of average intelligence sure doesn't sound like you're considering somebody's dismissal. There was no hearing notice, thus no hearing of charges can take place without a 24-hour notice under the Brown Act and the Sunshine Ordinance, and the opportunity for me and others to request an open session in the matter. Once again, the Fire Commission is asking for a broad interpretation of permitted closed session topics, and that because a topic pertains to dismissals, it should be allowed to be discussed in closed session. The problem with that argument is not only the Sunshine Ordinance, but also the Brown Act, Section 3B, Paragraph 2, and the California Constitution, which I read before, that specifically required these sections to be interpreted narrowly. I'm going to expand a little bit. There are only certain permitted topics under 6710B that are allowed to be in closed session. And one potential problem with a broad interpretation, anything that pertains to dismissal, is the downstream sections of the Brown Act and the Sunshine Ordinance, like 6712, requires disclosures
30 seconds.
Only for specified reasons. Well, if you broadly interpret 6710B and you allow several other things to be discussed in closed session, when they wrote 6712, they never considered those actions as having to be disclosed. So that's just another consideration to think about how narrowly you need to construe 67.10B. Thank you.
Thank you. Okay. When Patricia's ready, let's go ahead with the respondent.
Ms. Conner-Freed. Ms.
Okay.
Conner-Freed, are you ready?
I guess.
Okay, your 3 minutes begins now.
So the beginning of 2022, the Fire Commission got word that there were going to be about 22 potential non-disciplinary separation cases to come in front of them because of the health order that the city and county of San Francisco put out. The Fire Commission it's new ground for them. And at the suggestion of the president, she asked for an agenda item to be put on the agenda for the Department of Human Resources and the City Attorney's Office to come in and give them a more or less advice on how these potential dismissals of 22 or more members of the San Francisco Fire Department would work under the health order. The agenda was posted timely. The actual sites were put on the agenda, and we voted to go into closed session. You'll see the minutes are attached. It says who was in the closed session once the closed session ended, and there was also a under that closed session a discipline hearing, and we announced what the outcome was of the discipline hearing, but there was no action taken on the labor negotiations, which is an allowed item for closed session. And then we stand by our letter that was submitted to the Sunshine Ordinance Task Force for a breakdown of all of the statutes that we cited in that letter. And that's.
Thank you.
Thank you.
All right, members, any questions? I do have a question. It sounds like during that closed session, and correct me if I'm oversimplifying, but it sounds like it was a closed session that we're talking about. And was a member of the city attorney's office in the closed session? Is that what you had said?
Correct. So the Department of Human Resources Director, Mrs. Ctrl F, and the Deputy City Attorney that represents the commission.
Okay. And it sounds like you're saying that the city attorney's office was providing advice in that session. Is that correct?
Well, they were there to answer any questions. It was the Department of Human Resources that was providing the kind of like the breakdown on how these hearings would work.
Okay. All right. And so it was one representative from the Human Resources, correct?
The Department of Human Resources, correct.
Okay, and a city attorney, and then the members of the commission, they went into closed session, correct?
Right. So it was agendized as the conference with negotiator, labor negotiations, cities negotiations, Ctrl F, Human Resource Director, and Audris Graham, Employee Relations Director. Anticipated issue under negotiation, status of meet and confer concerning Commission's procedural rule regarding hearings for vaccination-related separation cases.
That's not the session I had requested. It was only the session on status and calendaring of pending disciplinary and separation cases. The Audris Graham and Ctrl F was in the previous session. It was also closed.
Okay, yeah, let's see if we can get that pinned down. Okay, so it sounds like from Mr. LaCroix that we may be talking about two different closed sessions. One of them being what the respondent was just describing, which is human resources. She was talking about its labor negotiations, city attorneys there. Mr. LaCroix, are you saying that there was a separate deliberation that did not involve those people that you're complaining about shouldn't have been done in a closed session?
That's correct. My petition was very clear. It was they went into closed session for 3 separate agenda items, and that first one, which was the labor negotiations, is not the one I was requesting. I was very clear that it's.
No, we only went in for 2.
I thought you said there was also a disciplinary case, but
Right. So
okay.
case number 2021-03 was the appeal from a 10 calendar day suspension for violation of 3 separate rules.
Okay, and that's not an issue here. We're talking about, it sounds to me like it was pretty clear from Mr. LaCroix in the documents that we're talking about something that may have been sort of a scheduling discussion. Yet I could see that maybe it was about scheduling 22 different employees. So I'm a little bit, I'm not sure if to the respondent, do you believe that Mr. LaCroix is wrong that the scheduling item that he's complaining about is separate from the HR labor negotiations closed session that you were just talking about a minute or two ago?
Is that for me?
Yeah.
Right. So it was all B and C were all to do with the on how to get these 22 non-disciplinary cases scheduled. So it is all part of a personnel issue.
You're saying how to get them scheduled.
Right. So we have to have a hearing, a separate hearing for all 22 potential non-disciplinary separation cases for members who did not get vaccinated.
Okay.
And that was all new to the commission.
Mm-hmm.
So there was discussion on how to proceed with personnel matters.
Was it about you were actually doing the scheduling, or was it more about trying to figure out sort of a system or a method by which to deal with the fact that you had 22 that you had to schedule in a sort of a special way?
Yes, that is correct.
Okay, so you weren't setting dates.
Well, not specific dates, but trying to get a feel on
how to do it.
Exactly.
Okay. Thank you. I don't have any further right now. Members, any other questions? Okay.
Yeah.
Yeah. Member Sugarman, sorry.
No, I said no.
Oh, okay. All right. Well, we could then, we may have further questions, but it may be that we just ought to deliberate amongst ourselves and figure out if we either have a strong sense of this one way or another, or if we can't make any decisions here, we would send it to the task force if we wanted to have a decision of some kind. as opposed to the last one, I don't think anything is conceded in this one. So I'm open to your thoughts, members. Anything, what you want to do with this one?
Just from what I can tell, it seems fairly straightforward to me. So I can imagine what would happen if it went to the full board. But also, if the question is a matter of determining whether we have jurisdiction, it seems as though we do, and that neither party concedes where they're standing with it. So that's what they would like to see with it, is for it to be determined by the task force. That's basically it.
Okay. Yeah, I think each of the issues is contested here. I think that the two sides have different opinions on propriety of the decisions here. So unless we were to, feel very strongly in one direction, then maybe we just send this on as it came to us and just say, yep, we got the jurisdiction. These are public meetings. And so let's forward it. And so I'll make the motion. Move to forward this matter to the task force. We find jurisdiction, and these meetings were public. This needs to be heard on the same day as the case that was just before us, 23095, since the parties are the same and the claims are not the same, but similar.
Motion to move this matter to the task force, finding jurisdiction, and that these meetings were public. The matter is to be heard on the same day as case number 23095, as the parties are similar but not the same.
I would second that. Unless you have something to add.
The parties are similar. I just want to clarify, and the issues are similar but not the same.
Parties are
the same, issues similar but not the same.
Matters to be heard on the same day as case number 23095, as the parties are the same and the issues are similar but not the same.
Thank you. Great. Okay. And
Seconded by Member Stein.
You got it.
Oops. Public comment?
Yes, please.
If there are any members in the room who would like to make public comment, please approach the podium. We do have one caller in the queue. If you would like to make public comment on item number 5, please press *3 on the telephone or raise your hand using the app. We have no one in the room. Would you like to hear from the caller?
Yes, please.
Hello, caller. You've been unmuted. Hello, caller. Do you wish?
I think you unmuted the wrong one.
Hello, caller. Do you wish to speak on item 5?
Yes.
Thank you. Would you care to provide your name? You do not have to.
No, thank you.
All right. Your 3 minutes begins now.
Thank you, Task Force, for taking my phone call. Good evening to all. I just wanted to say that if there were backdoor or behind closed session discussions about firing firefighter personnel, and it didn't involve information of, personal information of the firefighters, but it should be open to the public to understand how they went about deciding to fire members or dismiss members or non-disciplinary separate members, how that agreement went. If heads of department were in these meetings, the public should know. We invest a lot of money in training firefighters. We trust in their integrity and them serving the community. So we would like to know what happened to these 22 members and the process that they went through. And I implore the task force and the committee after them to genuinely give us a good look and to bring out to transparency the entire process that was unfolded to the 22 members. And clearly, Ms. Confrey just admitted to everybody that there were discussions with several people about how that was going to happen. And I know there's lots of people who would like to know what happened in those conversations. And thank you and good evening.
Thank you.
Thank you.
Okay, we can vote.
Right. Member Stein.
Aye.
Member Stein, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. 3 ayes, the motion passes. Item 6.
Yes, please.
Item 6. File number 23100, complaint filed by Jimmer Cassial against City Administrator's Office for allegedly violating Administrative Code, Sunshine Ordinance, Section 67.21 by failing to respond to a public records request in a timely and/or complete manner.
All right, do we have the complainant here, the petitioner?
1 moment, let me check this caller, please. Hello, caller. Are you here to speak on item 6? Hello, caller. We have Mr. Cassiel. 1 moment, please. Mr. Cassiel has been added as a panelist. 1 moment, please. Let me check a caller. Caller does not wish to be unmuted. If we have any callers in the room and you are here for item 6, kindly raise your hand pressing *3 or raise your hand in the app. I see no one in the online community who is here for this item.
Did you say Cassio is here?
He is here.
Oh, okay. So we have a petitioner, but we may not have a respondent present. And this involves city administrator? Yeah, city administrator's office. Is anybody here to speak on behalf of the city administrator on this matter? If not, then we'll go ahead and hear from the petitioner, Cassio.
Mr. Cassiel, I'm going to unmute you.
Hi there. James Cassio here, Jimmer Cassio. Start the clock.
Yeah. When Ms. Peterson's ready, you have up to 3 minutes.
Your 3 minutes begins now.
Okay, well, thank you for adding me to the agenda. Basically, if you look at the record, page number 32 of 41 is the letter to Mr. Yankee from Vivian Ho. That pretty much explains the whole thing. I did a sunshine request, and they're not done with the city administrator's office like they are most other departments' next request. So you have to email the department. So the city administrator's office, I sent the email, and there was a woman named Heidi, very responsive, very nice. But as you can see in the response, I initially requested it on October 22nd. They had to clarify something on the 23rd. I responded. They said they needed the 14 days additional extension, November 3rd. Upon the due date of the extension, they updated it on November 15th. They were basically needed to clear something with the city attorney's office. I was told I was going to be getting the emails that I requested, and then she said they'd be coming to me shortly. And then like a day later, I said, what do you consider shortly? And she said, by the end of day today. And then at the end of that day, I received the email basically saying that they're not going to give me the information that I've asked for. So, and then it goes on, Vivian Ho, Ms. Poe basically says, we tried to be helpful and inform the requester that he has the option of pursuing a personal records request. And I'm not quite sure what that is. I think that might be, I can request seeing my personnel file, which I've already done that. So that's not much help. And then she also states, the city attorney's office, due to personnel and privacy reasons, it is important to note that we are treating this request as we would treat a request from any member of the public, which means anything we disclose to the requester, we need to disclose publicly to other requesters with the same request. I'm an employee looking for some emails that were between HR and my boss, actually my boss's boss. And basically, I don't think, I don't think if any member of the public asks for emails between me, an employee, and HR, I don't think that would be appropriate. I'm the employee asking for emails regarding me, the employee.
All right, thank you. Okay, questions, members?
So the respondent is not here. Did we?
Yeah.
We're definitely sure of that.
Nobody here.
I guess I might have a question for the petitioner. So you already made a personnel records request,
Yes.
and the materials that you're seeking were not there. So that,
No,
okay.
go ahead, sorry.
No, that was really I just wanted to confirm that.
Yes, that's correct.
Okay.
And some of the emails that you were seeking, this is Chair Schmidt, some of the emails you were seeking would conceivably have been written between one city employee and another city employee that would have mentioned you. Is that sort of the gist of what you were looking for?
Yeah, it would have been email that was about me. Basically, HR, this person in HR, they don't really respond to the employees. So I've sent him about 2 or 3 emails and never got a response from him, but I believe he basically forwarded the email to the other individual.
Okay. Any other questions, members? All right. I think we're going to deliberate now. Well, we don't have a respondent here, and I would have some questions for the respondent about the objections. I don't like it when they push together the different objections, such as to say personnel privacy. I think that's it's bogus to do that. And in fact, I question just there may be some of this that might have protection as personnel. I'm less convinced that there'd be protection as private. I do want to just point out that the process, we're talking about public records and public access to public records. And so there is a different process that we don't really have say in, which is employees who are seeking their own personnel file, et cetera. But that's not what we're really here to do today. I think we probably just move it on and let the full task force decide whether there were violations of the Sunshine Ordinance in this case.
I just have like two additions. One is fairly, it's just a little one about in 6721 about what is exempt, which is kind of what you were talking about in terms of personnel, or in terms of personnel matters. So that's a question that I sort of just have more for deliberative, not for the parties present. But that's one thing. The other thing that I think is actually important from what I was reading is that this complaint is with the city administrator, and within the letters that I'm seeing, there's a lot of deference to the city attorney. So I would think that if this went to the full board, that like that's maybe what would happen. Like the city administrator would show up, like representative would show up and be like, "Oh, well, we deferred to the attorney, and the attorney said this." So, I would think that like something like this could be delayed unless the attorney was also a party. Like if we just put it to the board, right?
Are you suggesting that we ask that the advising attorney on this matter would appear before the full task force?
So I'm suggesting that that actually does sound smart, and also that if they didn't, that's what would happen when this came before the board, because that's what those letters seem to indicate, that we were going to give you this information, but then we consulted with the city attorney's office, and now we're not going to. That's what I read.
Mm-hmm. Mm-hmm. Yeah, I do agree as to this is one of those cases where their defense is basically, yeah, the city attorney told us to do this. Yeah, which, you know, it can be perfectly, it's not a final answer to anything, but it's a pretty common and often, you know, a pretty powerful justification, let's say. Well, if the city attorney wished to come in here, and although the administrator would show up at the full task force hearing and say, well, we, based on what we were told by the city attorney's office, technically, we decided that we would follow their advice,
Yeah.
et cetera, et cetera.
Personally, I'm inclined to make a motion that adds the city attorney, like what the recommendation that the representative comes in as well for a case like that, so that it doesn't so that it doesn't get pushed. Like what if that comes before the full board and the administrator says that? The representatives, obviously, from these offices say that.
Mhm. I'll defer to Member Stein if she wants to go along with that, but I'm not quite sure if I would expect that the city attorney would do anything other than say that they're not going to say a thing, they won't be questioned, because this was a client seeking advice, so it's within the attorney-client privilege. And I know that there is a provision in Sunshine that talks about how attorney-client privilege doesn't apply as it does elsewhere. My reading of the law is that it's pretty clear that that has been struck down by the California courts. And so to me, they would have the privilege in this case. And so I'm just guessing that even if you got their consulting city attorney in here and started asking them questions, they'd just say, sorry, I can't say anything because that was consultation with the client.
And that tends to be what we hear whenever we ask for, whether they want to go on record with whatever advice that they've given. Although the client has the privilege to reveal what the advice was if they want. But I think the client is still ultimately responsible for the decision that's made. They're being advised. That doesn't mean they have to take that advice. So it seems like they should be able to give a rationale of why they think something falls under a privacy or a personnel exemption wholly. The task force has not tended to be very accepting of arguments that if it has anything to do with personnel, it's all exempt, or if it has anything to do with, and privacy itself, as we've seen many times, is a very, very weak defense for not releasing information, because privacy law in reality barely exists. And it's just a very vague notion for a lot of people. And it doesn't mean that everything goes under that. So, I mean, we could say that we would like the respondent to be prepared to discuss exactly how this is an exemption that would fall under personnel or privacy, and why the entirety of the records fall under personnel and privacy, given the laws that say that you have to, narrowly pull out things that would fall under that and reveal everything else. I mean, we can advise that, but I don't think I tend to agree with Member Schmidt that we probably won't get very far trying to get answers out of whatever attorney advised them.
What, Member Sugarman, what do you think, if you had on this case, if you had the city attorney who was the advising attorney, if you had them here, what kind of information do you think that you might ask them about?
I understand sort of the advice from both you and Member Stein. I do think that's certainly probably the likely outcome, that they'll just say that it's privileged and they won't want to talk about it. It just seems to me that from what I saw in the letter, that it was just it was pretty vague. It's like, well, here's we're going to give you this, we're going to respond to this information, we're going to get an extension, and then, oh, we actually talked to the city's attorney's office and thus we're not going to. So for me, I'm literally just imagining it coming before us and the administrator saying the exact same thing when they get here. Oh, that's what we can't discuss. This is what the city attorney told us.
Yeah.
So I would just ask, I would want to eliminate the middleman, honestly. It's just like, I would want to ask the city attorney the same thing. It's like, well.
Although technically under the Sunshine Ordinance, even if they're advised that by the city attorney, if they're not going to give records due to for any exemption reasons, they are supposed to cite specifically what sections apply. And that is a weakness of their position.
And it does say that in the provision in 6721, there needs to be like a stated reason for the exemption.
And it has to come from you.
In writing.
The law that applies. So you can't just say it's a privacy right. You have to show us what section under how privacy rights are legislated that fits under.
Yeah, and I think in this, with these specific facts, the fact that they came back with a kind of response that they did, where they simply said, sorry, it's all personnel / privacy. I don't think that's sufficient myself. Not that I'm deciding the case. We're not deciding because we can't make a decision today, as I know I'm repeating myself. But yeah, I think that is the issue here is, whether or not you got advised that you shouldn't produce anything and you should give this response. Was your decision to follow that advice and go forward? Was that move in violation? And that's pretty much the way I see this thing going for the task force. Yeah, these are public records. We have jurisdiction. So the basic questions are clearly answered here. I don't know if I'm getting a sense that the members want to make a recommendation one way or another on this. And there's no need to make a recommendation. We can if we want. But it seems like one thing, I'm guessing we do pass this on in some form or fashion.
I mean, that sounds appropriate. I would just say that, is it possible to send a letter to the administrator's office as well, like asking before the hearing for a reason for the exemption? Like, is that possible to do?
Well, why don't, we could try to say that we're going to schedule this for a task force hearing. And in the meantime, we would ask the administrator's office to better explain the application of the cited exemptions to the actual withheld documents. How does that sound?
And I think that would help. Yeah.
Okay.
So you like to schedule this for the task force, but ask the administrator's office to better explain the application of the cited exemptions to the actual withheld documents prior to the hearing?
God, that sounded good. No, I'm just kidding. Thank you for catching all that over my garbling. Well, I don't know if that becomes a motion. But I think for purposes of what we're doing here today, we might, if you want to consider it a motion, we'll just say move to advance this to the task force since we have jurisdiction and public records, and to ask that the administrator, and then you've already Patricia, you've already got the wording on the rest of it.
And the request to the administrator's office is part of the motion?
Yeah, I think so. Yeah, that's part of the motion.
I would also add that, that we're requesting to know under 67.21B why these exemptions apply under the express provision of the Sunshine Ordinance.
Mm-hmm.
If you want to add something like that, right?
I like it.
I'm sorry, requesting to know why under 67 21B, these provisions apply.
Why these exemptions apply. Why this information is exempt under the express provisions of the Sunshine Ordinance. That's taken directly from the wording of the ordinance.
Yeah.
Requesting to know under 6721B why these exemptions apply under the express provisions of the Sunshine Ordinance.
Yeah.
Is there a second, please?
Let me just add one small thing, which is, and to determine a violation for failure to send a representative today.
Is that the last element?
Yeah, that would be the last element. And so now do we have a second?
I can second that.
The last element, and to determine a violation for failure to send a representative to the complaint committee hearing today.
Good.
Okay. Seconded by Member Stein. Proceed to public comment.
Yes, please.
If there are any members of the public in the room who would like to speak on item 7, please approach the podium at this time. If there are any members of the public who are in our online community, please raise your hand if you wish to speak on this item by pressing *3 or raising your hand in the app. I see no one in the room. I see no callers with their hand raised.
All right, we can have a vote.
Proceeding to the vote. Member Sugarman.
Aye.
Member Sugarman, aye. Member Stein.
Aye.
Member Stein, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. 3 ayes. Motion passes.
Thank you.
Thank you. All right, next item, and if at some point members want to take a break, we certainly could. I'm always inclined. Okay. All right. Next item then. Just speak up if you do, please.
Clarification, caller. Rosa, are you here for item 7?
Yes, I am.
One moment, please. Item 7, file number 23101. Complaint filed by Rosa L. against the police department for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21, by failing to respond to a records request in a timely and/or complete manner. We've added as panelists Lieutenant Chris Beauchamp and Rosa L.
Okay, the parties are here. We'll start out first with the petitioner, up to 3 minutes.
Rosa, are you ready?
Yes, I am.
Okay, your 3 minutes begins now.
So I filed a request for body cam footage. The request was filed on December 7th, 2023. SFPD did not respond until January 11th, 2024. That summarizes the part of the complaint about a failure to respond in the proper amount of time, as that is beyond the proper amount of time. I do see in the documents that SFPD sent to the SOTF that after I filed a complaint, they sent an email to the SOTF that I believe was intended for me, but they never sent that to me. So I just wanted to flag that for everybody. Email was still sent too late and after I filed a complaint. But just in case anybody references that email, please note that it never reached me because it was never sent to me. Further, I have concerns about the claim that there are no responsive records based on the rest of the context that I included in the packet that I sent to the SOTF Complaints Committee describing the body cam policy with respect to encampment resolutions. And I am happy to answer any questions regarding the details in that packet. I feel like it was pretty thorough, but also there is some, it's a very detailed concept, lots of ins and outs. So happy to answer any questions there. Otherwise, in my opinion, this is a pretty clear case. So I will stop now. Thank you.
Thank you.
We do have Lieutenant Beauchamp.
Evening, task force members.
Are you ready?
Yes, ma'am.
Your 3 minutes begins now.
The San Francisco Police Department stipulates that we did not respond in a timely manner. We did receive the requester's request on 12/7. We assigned that request to our media department on 12/8. And after we received the complaint from the Sunshine Ordinance Task Force, a review of our record shows that due to a number of unforeseen errors in our staffing policy, that request was not fulfilled by our media relations unit. Subsequently, we have adjusted our policies internally to ensure that a complaint like this does not occur again. We've adjusted the amount of people who are involved in requests, as well as the frequency of checkups on the requests to make sure that they are taken care of in a timely fashion. Subsequently, once we received the complaint on the 10th, we made a response on the 11th after review and researching of the information provided by the requester. We were unable to determine any responsive records based upon the specific information provided by the requester. We are happy to provide any documentation if she's willing to follow up with the additional information we require to fulfill her request.
Thank you.
So submitted.
Thank you.
Okay, members, questions?
I guess I have a question for the petitioner. Given what the police department just said, are you still looking to move forward with your complaint?
Yes, because this is part of a long pattern of SFPD not responding to my requests on time, unlike other departments, for example, the Department of Public Works, which does respond on time. Case in point, while they mention that they are addressing this systemic problem by making staffing changes, just this evening, while I was waiting on this call, I got a response from SFPD about a public records request that I filed on February 15th, and they just responded to it today, which is only 5 days later, but when I say responded, I mean acknowledged in any form. So not just responded, with records within the 10 calendar days, but even acknowledging it at all. And further, prior requests have been far more egregious than that, just sometimes not receiving a response for a long period of time. So I think in order for me to not move forward with this request, I would want to know some specifics about what changes have happened and when they've happened. Like, did they happen just this evening? And what are those staffing changes? And just a little bit more detail there. Then I would also want to know a little bit more about why the information I provided was not sufficient to identify records that are disclosable, just given the context, again, in the complaint that discusses the body worn camera policy at encampment resolutions, and specifically, SFPD Bulletin 23-166, which describes legal enforcement options for addressing illegal encampments, as well as the body cam footage required at such incidents.
Thank you.
This is Member Stein, and I mean, I would like to know the answers to those questions from Lieutenant Beauchamp. Can you tell us what was the problem with the process and the staff, and what actions have been taken to rectify that?
Sure. So I'll break the request down into 2 points. First is the fixes that we put in place. A review of what occurred in this incident pointed out that we had a single point of failure in our media relations unit. There was one point of contact that we forwarded our requests to, and the civilian supervisor, director of that unit, was unaware of what was going on with that one particular individual. At the time that this request was made, there was a confluence of issues that came up where that individual who received the requests was on leave and then was subsequently transferred out of the unit, which effectively made it so that the unit was unaware that requests were piling up when they were being directed to the media relations unit. Subsequently, in the early half of January, prior to this complaint being made, I directed those issues to the civilian director of the media relations unit. We have since then performed a initial training on California Public Records Act requests with the media relations unit. We've expanded out the number of points of contact with the media relations unit from 1 to 4. We've included a dashboard for the entire media relations unit to be aware of pending requests. And we've ensured that the civilian director is aware of requests when they come in via the portal. Whether it be happenstance or just good luck, going through our records, I actually assigned this request personally to the new point of contact at the media relations unit on the 9th of January, and I can provide that history if the Sunshine Ordinance Task Force or the requester would like it. We have a standing record of all of the changes in our GovQA system that tracks our PRAs. So I actually assigned this case one day before we received the complaint. Subsequently, regarding the specific request made by the requester, she did provide a very detailed document that appears like it came from the Department of Emergency Management. However, based upon the specific information that was provided in that document, we were unable to locate any body cam footage regarding the 2 incidents that she was requesting. I believe those difficulties were caused by the fact that the document produced by the Department of Emergency Management provides information that we as a police department do not track. For example, the information regarding the incidents that were requested identify a generalized neighborhood, for example, the Bret Hart area of the Bayview or Lower Nob Hill area of the Central. San Francisco Police Department tracks its records from either specific intersections or specific addresses in the city and county of San Francisco. We don't track our information based upon neighborhoods. Secondarily, the times in which the requests, the 2 pieces of information were requested, one was at 23:04 in military time, and the other one was at 23:11 in military time. So that would place them at 11 p.m. at night. When we reviewed records for our HSOC unit, it did not show them working at those hours. I even personally contacted the head of the HSOC unit and asked if his units were working that late. And he states neither during APEC nor as a standard operating procedure do his units work to that hour. So based upon this document, I'm unsure if the times that are quoted are the times that the police department was aware of the resolution going on, or if this was part of one of the other various city agencies that was located at the scene, such as DPW, ERT, HSH, or SFFD. So because we were unable to determine both the time and location, and upon a review of the subject matter experts, we were unable to provide any further documentation. If the requester can provide or ask for further clarification from DEM to see if there's a CAD number or a listed address or an officer involved, we would be more than happy to provide the commensurate BWC.
Okay, I don't have all the documents that were submitted in front of me, but it is the case, right, that a particular incident was mentioned, like a resolution incident and a particular date. Is that correct?
Oh, yes, it was for two specific instances, yes.
So do you have, I mean, are you saying there are like multiple incidents going on those dates and you don't know which one they're referring to because you don't have an address? Or, how much, how many,
I'm sorry.
I'm just wondering, like, was a search done and how much material, how confusing was it? If there's an incident mentioned on a particular date, how many record responses are you getting or how much body cam footage are you finding? And, why not just provide all of that?
So regarding the incidents themselves, we did have members of HSOC working that day on those days. However, we don't have any corresponding footage for those generalized locations and times. My understanding is that when asked for very specific information, we look for very specific answers. I believe it would be disingenuous to be asked for a specific date and time and then say, well, nothing met your date and time, but here's 25 videos that occurred that day. You figure out what applies to your request.
Okay. All right. Thank you.
Yeah, and actually, thank you. That was very helpful to me because it actually, I think, just to take what respondent has just said, I'm going to ask a question of the petitioner. That seems to me to be more information than I had been able to get out of the file. Is that new information to you that helps you understand this better? To the petitioner?
No.
No. Okay.
To be blunt, I can clarify what I mean by that, if that's okay.
Yeah, I guess, let me just, I'll let you clarify. I guess the thing that interests me is that apparently the records of FEMA, the police department is saying that maybe that doesn't necessarily correspond to when the police is involved. But go ahead and clarify. Thank you.
So, that may technically be true, but it's a so the way that these encampment resolutions work is that they're implemented by HSOC, which is a coalition of city agencies of which SFPD is a member, and these resolutions are scheduled ahead of time, and there are a limited number of them in any given day, because as you can see from that record, it requires a coalition of teams present, right? You're not going to just all of a sudden have DPW, DPH, ERT, HSH, MTA, SFFD, SFPD, and DEM just kind of showing up, right, whenever it takes time to plan that. So these are planned resolutions. Everybody's aware of them. They are the subject of a federal lawsuit, right, that's being appealed, et cetera. So what I'm trying to say is that, on 11/15, there were only 2 of these that are listed in this spreadsheet. And so I feel like it's very, very reasonable that SFPD would understand that I want the footage from when SFPD was at that resolution. I don't know what time during that resolution the officers were there, what time they left, right? That the date and That's, in my opinion, sufficient information. Like the time of the survey date, which is there in that spreadsheet, is less relevant. So in my opinion, pointing to that time and saying we don't know exactly when the officer was there at that time is deceiving or misdirecting, because SFPD would know when their officers were at this encampment resolution because it would have been planned ahead of time. So that's what I'm asking for, is the footage of officers at that encampment resolution on that day.
Okay. And do you have any knowledge as to, say, just with these two incidents, the likelihood, well, I'm going to strike that question. That was a bad question. Let me ask a better question. Do you know that there was body cam footage taken in these two incidents? This is a question to the petitioner.
It's not possible for me to know that for certain, but the reason that I am asking is because individuals, the HSOC record shows that individuals, homeless people at the encampment resolution refused, some of them, the government says refused service, which means that they are subject to legal enforcement options, which means that if there is a threat or execution of those legal enforcement options, that the police should, according to their own policy, activate their body cameras.
Okay.
I would like that footage.
Okay. Thank you. And to the respondent, is it possible that, well, when you went to look at these two descriptive, there's a certain data that you were given, and I know it's data that's based on the organization method of another agency, so there's not a direct correlation, but it gave you at least the dates to look. When you went to look, do you believe that you either one, you really couldn't figure out which incident Rosa L was referring to, or number two, you're pretty sure that there simply was no body cam footage for the incidents on that day? And I'll say that maybe it's option number three, other. I don't know. I'm just trying to figure out what you mean when you say I don't, I couldn't find body cam footage based on what I got in terms of the specification.
Of course. So I initially searched out those HSOC officers. It's a very small number of officers who are, well, belie that. There's a decent number of officers who are assigned to our HSOC unit. So I reviewed their assignment for that day. I reviewed their various calls for service across the city. I tried to correspond that against the date and times that were put in the request, and I was not able to match them up. I then contacted the lieutenant who's in charge of the HSOC unit, and to the requester's point, he made the same point, saying that resolutions are usually long-term scenarios. And when I gave him this exact same document and asked him if he had any knowledge or if his unit had any knowledge about being in either of those locations on those dates and times, and the first thing he pointed out was, if we were going to be doing a resolution, we would not have been out at 11 p.m. at night. So based upon that information, what the subject matter expert was providing, I wasn't able to determine if anyone at HSOC was at that generalized location definitely at that time. Now, if the requester is able to provide some more context, whether it was a specific location or specific CAD number, if she's able to follow up with the Department of Emergency Management and get us that more specified information, we'd be able to locate and definitively say whether or not there's any body-worn camera. The flip side of that coin is if we're required to take a generalized approach, I would have to have units go through every piece of footage that those officers went through that day and try to correspond it to that location and whether or not it came to a resolution. Now, if that is minutes or hours of footage, it may take an unknown amount of time just to sort through that to determine whether or not any of it actually applies to these two specific instances. And since there's very little information to go off of, it would be very difficult to say that it specifically involved the two incidents in question, because we only have a time where the officers said they weren't there and a generalized location that may or may not correspond to where the officers actually were.
Thank you. All right. And did anyone at your department make contact with emergency management to try to figure out which resolutions their references were referring to? I assume that there's going to be a number or a name that would commonly be used between their department and your department. And so I wonder if there's a way that your department may have contacted them and said, you know, which resolution was this, which resolution was that, so that you could figure out which footage was needed.
So I contacted the non-emergency number of dispatch myself to follow up just as one last point of contact. And I provided them with the same information that's in this document, the generalized location, the district, the police district, the date and time, and they had no records of any homeless related calls on those dates and times. Again, that makes it very difficult for us to find because the homeless calls for service are vast, and unless we're able to specifically attach one to a police response, it's very difficult to find. If memory serves from my limited experience in seeing the homeless related call for service board, some of those calls can pen for days, weeks, months, sometimes up to a year before it's finally resolved either through HSOC or some other means. So this call for service that comes up for the 15th of November at 23:04 hours may have been a call for service that came in months beforehand.
I see. Okay, so that could have been more than a small period of time just on that day, but it could have been a matter that lasted for several days. Is that what you're saying?
Yes, and because I'm only able to provide that limited information to dispatch, I'm only able to get a limited response back.
Okay, thank you. Any other questions, members?
And Rosa does have her hand raised.
I will I'll ask the petitioner. Is there anything that you briefly would like to add?
Yes, can I ask, am I allowed to ask questions to the respondent or no?
You could ask it of us, and just tell us what question you might have at this point.
Sure, I think I would want to know if I give SFPD an officer name, or if they told me which officers were assigned to HSOC for encampment resolutions for that day, if they could provide me with footage of the HSOC officers at encampment resolutions on that day. And when I say encampment resolutions, I mean the ones that are planned and in the spreadsheet that I provided. Because again, really want to point out here that we're not talking about homeless related calls through 311 or anything like that. We're talking about pre-planned multi-agency resolutions, of which there are a limited number every day, and which every agency in San Francisco would know who is assigned and when that resolution took place. So the focus on the time on this spreadsheet is an obfuscation. The question is about finding encampment footage of HSOC officers at that resolution on that day. That's not vague mystical knowledge that's hard to track down, like that's a concrete request. And so I'm trying to figure out what additional information to provide, because I reject the idea that I need a specific time of the day, because there are only, one or two resolutions that happen on any given day. So that's my question, is like what information would be needed?
Yeah, and I'll just forward that and see if Mr. Beauchamp has any kind of sort of tight response to that, like, A, we need this, B, we need this, C, we need this, the type of information that the petitioner may actually be able to come up with. Do you have any answer to that?
I can, of course, attempt to ask the head of HSOC if they had any homeless resolutions on that date. What would be very helpful is if the requester reached out to the Department of Emergency Management with the same document, and it doesn't have to be time. If they can provide what's called a computer-aided dispatch number or an instant report number, I would be able to locate body-worn camera footage within minutes.
Okay, great. And do you know, these are now body cam records that date back several months. Do you think if there are body cam records for that date, do you think that they still exist, or have they been destroyed?
My understanding is that they would still exist. I am aware that the Coalition of Homelessness lawsuit against the city is still in effect. So my understanding is that all homeless-related body cam videos are being retained.
Okay, great. Thank you. Members, I think I'm done with my questions. Nothing else from the members. All right. What do you think we should do with this?
Well, I mean, to me, clearly there's a lateness issue, just because of the response times, but I don't know that I would, at first I thought send it to the consent calendar because of the lateness issue, but I want to do whatever is most effective in helping the petitioner get the footage that they're looking for. So, I mean, I think there's no debate that there's a 6721 violation.
For timing, yes.
But I'm wondering what else we can do to make sure this information gets shared.
Yeah, I see this as being, I think both sides have a good point on this, and there may be a slight level of sort of chips passing in the night. It seems like the description that is given by the petitioner to the police department seems pretty specific, and yet I can also see that the police department would look at that and say, well, that doesn't help us narrow anything down. Then the petitioner says, but, I'm not talking about every single encounter out on the street. I'm talking about these, organized multi-agency resolutions. And so I think we should forward this and ask that at least the task force confirm that there was a timing violation. I think that's sort of, we can't really decide anything further here. I think it's good to know that the 60 days doesn't end the availability, hopefully, for these two incidents. And so I would encourage the petitioner I'm not saying that this is like an optimal answer, because it's possible that this should be worked out between these different departments, that they have universal, identifiers, et cetera, et cetera. But it might be that if you found out from emergency management what these specific notations, what they refer to, is it, resolution number, 324, or with a name or whatever. I don't even know how they categorize them. That might be a way to get this stuff. And then you take that back to the police department. That's just more my practical advice, as opposed to what I'm actually, supposed to be doing here, which is just deciding, what do we do with this? We find a violation, and what else do we do? So,
I'm curious if the petitioner goes to the Department of Emergency Management and says there were these actions that took place on this particular day related to these resolutions. Can I get the CAD numbers of all the, calls that came in that were in this geographic area on this date? Like, whether the DEM can even provide that? Like, I don't know how that works. Right?
Yeah, and I don't either. I would think that, they may claim some exemption that I'm not aware of right now. But you're right.
I just don't know that they have in their documents or in their database something that would allow them to connect these resolutions to particular CAD numbers.
Yes. Yeah. Absolutely. It's certainly not a guarantee that you're going to get anything better than you've already gotten on this. But, in terms of like just trying to do further investigation on this, and I know, you're here, and so you've obviously spent a lot of time and effort on this. You obviously care. And so I'm just trying to figure out, rack my brain with my knowledge of how this city departments work. Sometimes they just don't necessarily all talk to each other, and that can cause problems. Okay, motion. Let's move this forward to the full task force, because these are public records within the task force jurisdiction. We recommend a finding of a timeliness violation under 6721.
Look forward to the task force to consider and find that there is a finding.
We recommend a finding of a timeliness violation as conceded under 67.21.
I second.
And let me and to consider the sufficiency of the response under 67.21. Still second? And I'll explain this is not part of the motion. I'll explain is that since the petitioner doesn't have the records yet, and they've asked for the records, and the police department they've answered saying, well, that's not enough for us to go on. Do we feel like the police department has done enough to respond here in terms of their substantively? And I'm not saying we answer that one way or another. I just think that we still have to figure out if there's also a failure to, produce the records. That's what I meant by that.
Motion that there is jurisdiction and that the requested camera footage is a public document, forward to the task force and recommend a finding of a timeliness violation as conceded under 6721, and to consider the sufficiency of the response under 6721.
21.
Second.
Seconded by Member Sugarman. Public comment. There does not appear to be any members of the public in the room. We do have one caller online with their hand raised. If there's anybody else who would like to speak on this matter, please press *3 on your telephone or raise your hand using the app. Shall I call the caller?
Yes, please.
Hello, caller. You've been unmuted.
Oh, hello, can you hear me?
Yes. Would you like to speak on this item?
No, I'm the petitioner for the next item.
Thank you.
Okay, thank you.
Okay, so let's vote.
No other callers in the queue.
Yeah.
Taking a vote. Member Stein.
Aye.
Member Stein, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. 3 ayes, the motion passes.
Can I just say, I think it would also, just as the extra thing, it would be good for the petitioner to go to DEM in the interim between this going to the full task force and see, can you get responsive, can you get the information you need from DEM to provide, to get these records from the SFPD. And if that information is not sufficient, I think that would be important for us to know at the full task force meeting. If just, if there really is no way to get the CAD numbers related to these particular incidents, then this is sort of a potentially a dead path to actually being able to get these documents.
Yeah.
We would want to know that.
Agreed. Thank you, Member Stein.
And how is that captured?
It's not captured in the
Okay.
in the resolution. I mean, in the order.
Okay.
Motion. It's not captured. It's just a suggestion to the petitioner so that we have more information when it goes to the full task force.
Okay, let's go ahead with the next case, which is the last complaint of the day.
Item number 8, file number 24002. Complaint by Anonymous, ACU, against the Fine Arts Museum for allegedly violating Administrative Code Sunshine Ordinance Section 67.7B by failing to provide a description that is sufficiently clear and specific to alert a person of average intelligence and education whose interests are affected by the item, that he or she may have reason to attend the meeting and/or seek more information on that item.
Okay, I believe that the petitioner is present. Is there a representative for the Fine Arts Museum available?
Let me check this call. Hello, caller. Are you here? Are you a party to item number 8?
No, this is Ann Trudeau.
Thank you.
Okay, so
There does not appear to be.
number 8, Anonymous v. Fine Arts Museum. It sounds like we do not have anyone here on behalf of the respondents. If they do suddenly seem to show up, just give a shout, but let's go ahead and assume that they're not here. And let's hear, and again, to the petitioner, It's a pretty big record we have here. This is a lot of documents, although there's repetition in our file. But the members have had a chance to look. So we know pretty much what the case is about already. But we're going to give you up to 3 minutes to give us an analysis, a summary of the case. When Ms. Peterson is ready.
Petitioner, are you ready to begin? I'm going to unmute you. Hello, are you ready for your 3 minutes to begin?
Yes, I am. Thank you.
Your 3 minutes begins now.
Okay. Good evening, task force members. Thank you. I'm sorry I wasn't able to stay in person. This complaint refers to 7 separate occasions in 2021 and 2022, including the Fine Arts Museum of San Francisco Board of Trustees meetings on January 19th, February 9th, June 8th, October 12th, and December 7th in 2021, and the meetings on June 8th and November 9th in 2022, at which the Fine Arts Museum of San Francisco Board of Trustees discussed an item, specifically JFK Drive access, that did not appear on the posted agenda. The FAM Board of Trustees' repeated discussion of an item not appearing on a posted agenda appears a clear violation of Administrative Code Section 67.7A for failure to provide a meaningful description of an item, as that term is defined by Administrative Code Section 67.7B. Fine Arts Museum Board is clearly a policy body, as that term is described in Section 67.3D. At all 7 of these meetings, JFK Drive access was discussed, but no description of this item was included on these meeting agendas. Therefore, the agenda item under which the JFK Drive access was ultimately discussed, namely report of the director and CEO, Thomas Campbell, was not sufficiently clear and specific to alert a person of average intelligence and education whose interests are affected by the item that he or she may have reason to attend the meeting or seek more information on the item. The fact that FAM Board of Trustees officials specifically and properly notified the public of the JFK Drive access item at the January 18th and February 8th, 2022 meetings, and then failed to provide proper notice for the next 2 Fine Arts Museum's Board of Trustee meetings appears a deliberate effort to keep the discussion of the people's business out of full view, violating both the spirit and letter of public meeting and open government laws. Based on the procedural question I asked you about earlier in regards to 24003, I will be planning to file a separate complaint under I believe it's 67.43 for willful failure to uphold Sunshine Ordinance duties or obligations. I appreciate your time and thank you for your efforts on the task force.
Thank you. All right, members, we have 1 witness. Any questions for the witness?
This is Member Stein. Sorry, so I'm just kind of looking at my notes here. So you also talked about thinking are a number of public comments that were not submitted prior to the meeting.
Yeah.
Do you know if those are public comments by people who were at the meeting, even if they were not submitted prior to the meeting?
No, I don't know that myself. I was not at the meeting, so I don't know. But I do know that, all those comments, if you notice, are time-stamped with a timestamp and date that clearly indicates they were received after the meeting had ended. So I would assert that they are improperly included as part of the minutes for that meeting, as they do not clearly and accurately reflect discussion or testimony received at the meeting.
Okay, I'm just trying to find, couldn't really find anything in the Sunshine Ordinance that said that only public comments on an item that were received before or before the meeting could be published. So I'm just, do you have any citation there or?
No, I did not see a citation. What I saw, I mean, knowing that just minutes are supposed to accurately reflect what occurred at the meeting, that seems improper. And then only additionally what I have is the instructions that I believe are included on the Fine Arts Museum agendas, as well as the agendas of all of their departments and the board, that notes that any written testimony should be included should be submitted prior to the start of the meeting.
Okay, thank you.
But as far as a specific site in the Sunshine Ordinance, no, I could not find that myself either.
Okay, thank you.
I'm reading 67(7)(a), and it talks about how agendas need to specify either a proposed action or a statement that an item is for discussion only. And it certainly doesn't seem to me that there was any proposed action that would really relate to what we're talking about here. Are you claiming otherwise, that there was a proposed action involved here?
No, but I referenced the violation of that section because it also includes, an item to be discussed.
Okay, so you're not thinking that it's a proposed action that they should have been more clear about, but in fact, they should have been more clear that this was for discussion only?
Absolutely. I mean, or
Okay.
including it at all, not included at all. And then on the two that they did include it, it was a meaningful description. JFK Tribe Access was included as a sub-item under the director's report. But then for that meeting and for the February 8th meeting, and then two subsequent meetings, the JFK Tribe Access once again disappears, but was clearly intended for discussion and was discussed at the meeting, but not included on the agenda. I mean, nor was it included on the 7 dates that I gave, the 5 dates that I gave in 2021.
Okay, so under 67.7A, there's a mention in the first sentence of how the agenda must contain a meaningful description of each item of business. And so I think that this would need to constitute an item of business. That's what you would agree with me that this you believe this qualifies as an item of business under that provision, correct?
Absolutely. Because, I mean, as you may know, the context of these meetings and the timing of it was during a period in which the permanent closure of JFK Drive was a very heated topic among residents in the city. There was strong opinions on both sides, so much so that it ultimately ended up on the ballot. And given the nature of all, like those attached items, the written testimony that Task Force Member Stein mentioned, they were, I believe, 45 of the 45 comments were all in favor of reopening JFK Drive. So they feel very slanted and skewed towards one side, and given the prevailing opinion within the community, it was not reflective of what the opinion was in the community. As I said, there were very strong opinions on both sides.
Got it. Okay, thank you. I think I'm good.
And if you don't mind, I mean, I would like to say that in support of my position that this was an item of business, they did include it on the agenda for 2 meetings, but then it disappeared again.
Got it. Okay. Well, I guess we may want to what do you call it? to make a decision, talk amongst ourselves.
Are we on to that portion?
Yeah.
So I understand what your question was getting at, because I did kind of go through and I looked at, okay, every time this came up as a item, was there any discussion among the Board of Trustees, or, was there any action taken? And in all the meetings whose agendas I reviewed, it doesn't seem like members of the board discussed it, although in a couple cases public comment was taken, but it wasn't like it was listed as an item for discussion or action, and like no discussion took place really among the members and no action took place. But what was interesting is the whole way all the agendas were done, of like, it's a report from this committee or that committee or this person or that person, and under some of those items there were resolutions passed.
Yes.
And
yes,
they were not
yes.
labeled in advance what those actions were going to be on. So I saw what I feel like is a violation of the need to have clear agenda descriptions and consideration for, things that are actually being framed as actions or discussions. I mean, for things that should be actions or discussions, because actions were taken. Although I didn't really see real discussion going on other than a report and then maybe some public comment, but not real discussion among the Board of Trustees on this JFK issue or any action taken on this JFK issue. But I felt like there was violation on other items where they were passing resolutions and the item was just listed as a report, but then a resolution on something specific was passed. So
Yeah, I could see that. I didn't, I don't know if I got as deep in as you did on that, but I could definitely imagine that. Yeah.
May I make a comment?
Although I think that well, there's no proposed action. Obviously, nobody's claiming, and I don't think I don't think they could have taken an action, because they were just talking about what other agencies are doing and sort of complaining about it. Like, what is Rec Park going to do here to us?
Okay.
Yeah. I don't know if we are actually in sort of these Brown Act categories of item of business, proposed action, but we may be. I don't know. Yeah, in discussion, in whether they failed to explain that this is for discussion only.
but like what I'm saying is it was all framed as a report, like someone's reporting on something.
Yeah.
And then it will say in the minutes, like, no discussion among BOT, but then sometimes public comment was taken. So it just didn't seem like it was an item it wasn't for discussion or action. It was just like, we're going to report on what's happening with this right now, or.
Yeah.
So, I mean, it does seem like it just seems like the contention in the way the complaint is phrased is that, like, JFK isn't necessarily brought up in these minutes. And I understand that we're discussing, I'm following that we're discussing between whether there was a discussion or an action, and what Member Stein has said that there is a report contained. But for me, when I was looking at the February 8th minutes, I was kind of looking to see if JFK wasn't mentioned at all. And then I was also looking at what I first saw, what Member Stein was saying about the public comments, which also seems sort of insufficient in some way. But there is a significant report on JFK in there. Like, I mean, there is, it's not like they were like, oh, this doesn't exist, and in addition to a significant report, there was a notation. Again, putting those two things together, there kind of is not within the board, but certainly a discussion happening within the meeting with many members of the public who are voicing their concerns. And, looking at this, this is, as many of these things come forward, kind of separating between, this is one of those things where obviously, I've followed along as well with the JFK Drive, and the way that it sounded, from the petitioner coming forward, it sounded like it would have been something for me as a member of the public that would want to know, oh, that they were discussing this. And if I saw these minutes, it does look like they disclosed that. It does say, at least in February 8th is the one that I'm looking at specifically.
Oh, in the minutes, but yeah, but in the agenda, it's not
Okay.
mentioned. It's JFK discussion, that there's going to talk about JFK in many of the agendas. But then, but in the minutes, it reflects that they did report on it, but they didn't necessarily have any discussion on it or any action on it. But in two cases, at two meetings, they took public comment on the report that led to people to comment on the JFK portion of it. You see what I'm saying? I mean, I went through the minutes of everything, but it's really how it appears in the agenda that just says like report by so-and-so. It doesn't say that the report is going to talk about JFK or this or that or the other. And in reality, the report talks about like 8 things, but those things are not mentioned in the agenda. So if you were a member of the public wanting to talk and wanting to hear what they had to say about this, you wouldn't necessarily know they're going to talk about any of these things because it just says a report from the chair of so-and-so, committee.
Okay, so I will just add then, given very largeness of this packet and that we don't have a representative from the organization here, like it's really hard to tell. It certainly seems like on the face that it is within jurisdiction. And that we don't have any like response from them to say, well, there was some other information that they're not including here, for example. That's what I would be looking for, is some other like announcement that this would come up.
You could even make the argument, and I think this is a little bit more something that we probably end up talking about when this thing goes before the full task force. You could make the argument that, well, it's like they buried the lead here. It seems like everyone who was at that meeting was there probably to talk about this issue, and yet the agenda item is report of so-and-so, and is that misleading? Maybe that's kind of what the issue is here, is can you just say, well, we're just going to have someone give a report and then that frees you up to talk about anything? I don't know if it does.
Yeah, and I do want to say though, it's endemic in all of their agendas. It's like, it's very rare that they talk about, it seemed to be in the agendas that I looked at, rare that they identify any issues in advance. They just say report from this person, report from that person, report from this other person. And so anyone who wants to go to their meetings and understand like what are the issues they're going to be addressing would have a very hard time knowing it, whether it had to do with the JFK drive or anything else.
Yeah, you'd have to have not just read the agenda, but read the entire content of each item that's in the agenda to find out if it is included in something called report of. And I don't know.
It's not even clear that they would have to put supplementary documents in their packets if they're not identifying things as for discussion or for action. But that's why I'm saying that. Then I was surprised, and I didn't see it with JFK, but with other items, actions were taken, resolutions were passed, votes were taken on things that weren't specifically mentioned other than this is a report from so-and-so.
I see that now. Sorry, I'm looking at the agenda.
Yeah. Well, I think that we are definitely going to have the full task force look at this, and there may be multiple either issues or angles to approach on this. So does anyone want to make a motion?
Yeah, I can make a motion that these are public documents under our jurisdiction and that we will forward this case to the full task force with a recommendation to consider whether there's a violation of 67.7B for clear agenda descriptions and a violation for including public comments that were received after the meeting.
I'm sorry, Violation for receiving public comment after.
A violation for including public comments in minutes that were received after a meeting took place.
Motion that there is jurisdiction.
Public documents under our jurisdiction. These are public documents under our jurisdiction.
And forward to the full task force with a recommendation to consider a violation of 67B for clear agenda descriptions and violation for receiving public comments. Oh, I think I missed
For
this.
including public comments that were received after the meeting. Sorry, and I do need to change one thing, which is this is public meeting under our jurisdiction.
And violation for including public comments in the minutes.
That were received after the meeting. Public comments that were received after the meeting.
Sorry, I want to second the motion, but I want to first understand. I understand the nature of what you're saying, the second part of it, but I just want to understand where that's a violation within the Sunshine Ordinance.
That I have to look at.
Okay.
Like, I just think it's something we should consider.
Yeah.
Like,
That
is there
they
any- I don't know. That's why I was kind of looking through the Good Government Guide and elsewhere, and I need to review the ordinance more clearly. It may not be under the ordinance, but I just thought put it in there because it's very unusual. It's unusual.
Well, it seems unusual that they would have such a significant discussion for something. I mean, I think that like just for argument's sake, there is general public comment. Like someone could come up and talk about basically, I mean, in all of these meetings, right? You can come up and talk about basically anything, correct?
Right, but usually you only include public comments that were actually made at the meeting or that were submitted prior to a meeting. And so I just don't know if there's anything that says, like, what do you do about public comments submitted after a meeting? Should those be included as a reflection of what happened in the meeting minutes? Or should they not be there? But I just want to make sure, Pat, that you, Ms. Peterson, that you change it to say that this is a public meeting under our jurisdiction, not public records.
Public meeting under our jurisdiction.
Somebody else might know of something in the Health and Public Records Act or something like that
Yeah.
speaks to this.
Yeah.
Yeah, there may be something out there, or else we just have to make the call.
Yeah.
You know, it
Yeah.
doesn't seem like it should be.
Well,
violated.
I understand. I generally agree with where we're headed with that. I just want to kind of hear the motion again, just so I can.
Hi, this is Victor. Can you hear me?
Yes.
Yeah, I would suggest not calling them public comment because it's a letter or a memo.
Oh, okay, including letters received after the meeting?
Yes, public comment only
Yes, you're
occurs
right.
during the
You're right.
meeting,
Yeah.
and you can give a 150-word comment of your public comment, but I don't think that's what we're talking about.
Yeah, I thank you for that clarification.
Is that public letters or letters received
Including
from the
letters
public?
received after the meeting.
And just so you know, generally, anything I received after the meeting, I do include as part of the file. I do not generally include public correspondence as part of minutes, and that's just something that body does. But usually public correspondence is just part of the file and not part of the minutes. In general,
Right.
if we receive it before or after, it's just part of the file.
Right, okay.
To restate, these are public meetings under our jurisdiction, and forward to the full task force with a recommendation to consider violation of 67B for clear agenda
Wait,
descriptions.
67.7B?
67.7B
Uh-huh.
67.7B for clear agenda descriptions and violation for including letters received after the meeting in the minutes.
Yeah.
Okay. That was a motion by Member Stein, seconded by Member Sugarman.
Two things, just, well, one is, do we want to say anything about the representative not showing up today? We don't have to. I just wondered if that would be a big help. And also, I think just on this point about the after submitted stuff, I don't even know if we're going to really find anything that's a sunshiny kind of issue. You know, it's not like lack of disclosure or, you know, lack of transparency, but we'll see. But we have unless you want to mention that representative, we do have a seconded motion, so we could go ahead. Whatever you want to do.
Can we just note that no representative has shown up? Do you remember the number of that? Is it 6721 something?
I think it's 21 somewhere.
Yeah, let's just add it so it's clear that a representative did not show up. Say and consider a violation of 6721 for not sending a authorized representative to the hearing.
Okay.
That is actually, I'm sorry, 6721E.
B as in boy.
E as in eagle.
Okay, deleting a representative did not show up. Replacing it with, and consider a violation of 67.21 sub E as an eagle for not sending an authorized representative to the meeting.
Yes.
Okay.
Public comment.
There does not appear to be any members in the room. We do have an online caller with their hand raised. Hello, caller. Would you like to make comment on item 9? 8.
Yes, I would.
All right.
Yes.
Your 3 minutes begins now.
And Turbo, again, I believe 6721E is failure to send a knowledgeable representative to the meeting. But my comment is that as an outsider, it's near impossible to understand from the agendas and the minutes what took place at these meetings. And that's been the case for a number of years. And I don't think that you can make referrals for whoever is responsible for writing these agendas and minutes to get some kind of sunshine training, but they definitely need something there. This is a major art museum known throughout the world, and they're using taxpayer money for purposes that are impossible to understand what they're doing. I rarely see opportunities for public comment at their meetings, and I don't even see draft minutes. So it's something that's been going on for a very long time. And I would urge the task force to do what they can to rectify the problem. Thank you.
Thank you.
Okay, we can vote.
There are no other callers in the queue. Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Stein.
Aye.
Member Stein, aye. 3 ayes, the motion passes. Item 10.
Yes, please.
Item 10, file number 23097. Hearing on the proposed edits to the Sunshine Ordinance Task Force complaint procedure to expedite complaint processing per the Sunshine Ordinance requirements.
Okay, so this looks like the highlight of the year.
Excuse me one moment. Ms. Trudeau, I am lowering your hand.
Rules changes. Okay, well, everyone, you know where I stand here, and I certainly could answer any kind of questions. I may be a bit forceful when I write these kind of things up, but this is my proposal after we had our discussions over the last, say, 6 months, intermittently, and trying to figure out a way to do this is not exactly that easy. I don't know if this necessarily covers every possible way that we can change things, but I took a little bit of a different approach this time, which is to try to hit one thing, try to figure out a way to try to make it simple, to try to make it clear, and yet to try to actually not just make some incremental adjustments, but to make a pretty significant change, because it seems like, based on what I set forth here, that the change has got to be it should be significant in terms of trying to get that time down. And the time not only to satisfy the statute, but also to give people what they probably want, which is something that doesn't take over a year to get your records, to get your answer. And then also, in that process, I think it fits hand in glove with the idea that these committee hearings that we have, they seem to be somewhat of a superfluous exercise when it comes to looking at a file, because often, we don't make a recommendation, and so everyone's got to look at the file again anyways. And so why not we use these trust 3 members in a committee to come up with something that the task force authorizes them to do based on what actually the way this thing was written, this Sunshine Ordinance, and the actual language that was used.
So I actually I was waiting to do this until now, 'cause looking at the agenda for tonight, actually, I thought it was sort of related to this item. So, in terms of how to change the procedure, so on each of these agenda items, it says Part A is determination of jurisdiction over the complaint, discussion and action, and then hearing on the complaint, discussion and action. Whereas tonight and what I recall as all other times I've been on this committee, we hear the complaint and then we determine jurisdiction, right? So, I guess my question is, I mean, in addition, I did read your letter and I have been looking over the proposed changes, but would that change?
Would the jurisdiction determination change?
Well, I mean,
No.
no, to invert it. Yes. So to where we would be able to, I mean, because that's basically what we've discussed is like kind of how to make this a more efficient process. So, and also that there are many times that we know what the jurisdiction answer is fairly immediately. So that is my question, is whether we would invert it and just determine the jurisdiction and then hear from people if we needed to hear from them. Because that's the question about it, forwarding it onto the full board. Is a jurisdiction issue.
Yeah, I guess I'll try to answer that, although maybe, hopefully this will answer your question. I consider the jurisdiction question to be sort of like, well, what do you mean? Like, when have we ever not had jurisdiction? It's very rare that we're even questioning whether there's jurisdiction. I don't quite get it. I mean, to me, it's like, okay, yeah, jurisdiction. It's 1% of the whole thing of what we do here. And so I know that, they talk about jurisdiction in the ordinance and they talk about jurisdiction in bylaws, but I don't understand why that gets so much emphasis, because it's not a big deal. But what I would say is, yeah, whatever we do, first, if you want to spend 2 seconds saying, yeah, we have jurisdiction, okay, that's what we do, and then we get beyond that, fine, and then but this would be, we do more than just decide whether we have jurisdiction.
Right.
We do all those other things too.
No, I understand.
Right now, I was going to say we have discussion and action, but our actions are limited to, we send it to the consent calendar or we send it to the full task force. Those are our only possible actions.
Yeah.
Right now.
Mhm.
And I just want to also add to, and I think what this envisions is that we make a determination, which is binding, and then the time, the clock starts ticking about like how soon this material needs turned over. But the other thing about jurisdiction is we're supposed to be considering whether we have jurisdiction, but the reality is like, yeah, 9 times out of 10 or 99 times out of 100, we have it. And when we aren't sure, it goes to the full task force because we're not equipped to figure it out usually on our own, or we're requesting that our attorney come in, our legal counsel come in and do some research and give us advice about whether we have jurisdiction. But we're very rarely determining like that we never are determining on our own that we don't have jurisdiction.
Right.
We don't exactly know what you're supposed to do. The rules as written, in my opinion, are kind of squishy in many ways. And it talks about determined jurisdiction. So what if we say there's no jurisdiction? What do? There's no like off ramp there. And so we're not really doing anything.
Right. No, I agree I understand.
And so I think if either we would, make a recommendation or whatever, but we're not really doing anything here, partly because I think the task force could say, oh, we decided, we vote, there's no jurisdiction, and overrule anything that we do here. They could. The one thing that's a little bit more subtle in the way I wrote it is that I tried to substitute for the word hearing, I tried to substitute the words review or meeting, because then we're not committed to having that word hearing show up. When it's not, already written into the law that you have to have a hearing. We could, have a hearing. It's not that a hearing can't happen, but I didn't want to stick with the language of hearing, which seemed to imply this whole thing that we do here, where I'm not sure if I think this whole thing that we do here really is anything other than a lot of people showing up for duplicative effort. And so in a way, I mean, the first time I know Member Stein or Vice Chair Stein and we tried to make some changes a while back, and my recommendations, our recommendations that went to the full task force, very little of them were adopted. One of the things that those reflected was partly my idea that this whole committee business is maybe you get rid of the committee part of it if they're duplicative and just go straight to the task force. This is kind of like a revamp effort where it's like, okay, well, if we're stuck with the idea of these committees, because I don't know if other people they like having committees. So if we're stuck with having committees, well, then let's do something with it as opposed to just kind of come and play with our toys for a while we sit.
Well, the full board seems supportive of that too.
I hope so.
They seem like they were in terms of giving us more authority.
Yeah, well, there will be some dissenters on something like this, and but that's fine. I have no problem with that. I certainly do my share of dissenting.
Oh, I have a couple comments too. I don't know if you're.
No, I'm done.
So I thought the rationale, as it was laid out was really concise and honestly very hard hitting. And I thought that was a good approach, just saying like, let's look at the language here and what it's saying and, what we're supposed to be doing. And I think it is pretty compelling. I think there's this argument that like, oh, we only have to meet and decide that it's, public docs under our jurisdiction, but we don't have to make the ultimate decision. We just required to do that. But when I read the language, I'm like, I don't agree with that. Actually, I think it's pretty clear that the deciding that it's public documents we have jurisdiction is supposed to lead to a determination, which isn't instantly supposed to lead to some compliance with that determination. It's not, I don't think you can like really sever those. So to me, it's compelling the way you laid it out and kind of brought attention to those pieces of the Sunshine Ordinance. But some issues I wanted to point out. So it says the procedure says a petitioner who designates 67.21B will get this kind of expedited look. But in reality, most petitioners don't say 6721B. They say 6721 only. Like this is something I noticed as I've annual reports, that petitioners will come in and they'll just give a number heading that's kind of general. But then when we make determinations, we try to be more specific and we'll be really on point about, okay, this is the exact subsection that is violated. But the petitioners often just mention the overall section. So
21.
Yeah.
Okay.
Yeah. So that's just something I wanted to point out because it might affect, how you write this.
Yeah.
And then I started to think too about, okay, what do you do with something like, here are the possible objections. Suppose there's a 6721, but it's really unclear, like we don't really know where to stand on questions of jurisdiction, which I know doesn't happen often, but 1 out of 100 times maybe it happens. Or we don't really know where what we think of the exemptions that are being claimed, for instance, and not with divulging certain information. And right now, those always come if there's a question about whether this is an appropriate exemption or whether this is actually under our jurisdiction, those always end up going to the full task force right now. So you're suggesting that we, from the committee perspective, decide it in committee, right? But I'm just wondering what happens if we're not sure, like, and we need to get counsel or something like that.
Those are the ones that move on, right?
I mean, I guess, yeah, we could just say, okay, this has to move on. This is not something that we can decide here right away.
The way I thought it's partly in order to get it passed, get this change passed. But what I thought is that if we give the committee if everything is presented to us, jurisdiction, public, and violation, and it's all of 21, and I'm just talking about 21, then we do a determination, we do an order. Boom. If we don't get all those things, then we kind of go, then we kind of have, okay, well, what we can say is, well, we're not sure, we don't have enough in front of us to show us that we can make a determination or an order here. And so, you know, I could change, or we could change this to give the committee the ability to dismiss, to say, well, there's no violation here. But I didn't put that in because I thought if we don't find a violation, but somebody did ask for a 21 determination, and we say, well, we can't find all the elements that we need to give you a violation. I think then we kick it to the full. And either, you know, they say no violation, or they might answer one of those questions, like you were saying, that, you know, we may think we just can't get enough to get there. But on the other hand, I wouldn't want to sit in this committee and say, oh, well, you know, just us three, we can't figure out this gnarly exemption question or this gnarly jurisdiction question. We don't have enough. We've got to go to the full task force. We've got to let them decide, because I think that's passing the buck. I think that we have the ability to do that. And there's nothing in the statute that says that that's a better way to decide it, or that the law asked that it have to be a vote of all 11, or, you know, because there's nothing in the law that talks about some kind of, like, you know, being in here in front of all these people and getting that decision made. The only time I can think that we couldn't make the calls here, make the decision, if we had all those elements, is maybe if we wanted something for the city attorney's office. Like there's a legal question on exemption, maybe a jurisdictional question, and we're like, oh, I don't know if I can answer this. I could see that as a thing that could possibly happen. I mean, I have the advantage of, I generally, or are we on public record here? Jeez, they're listening to me. I generally kind of see the process of getting a question to the city attorney's office and then getting an answer, and then looking at the answer as being like, how many years is that going to take, or how many months is that going to take? but also the answers are always a little bit underwhelming to me. And I have the advantage that I can just say, okay, well, then I'll look it up, but I'm the only one here who can do that. And I'm not going to like impose on you to say, oh, you should take my word for it, because that's not your job. Your job is to listen to what I have to say and figure out if it makes any sense. But if there is a complicated legal issue and people don't feel like they've got enough there, that they feel comfortable enough that they see that there's a violation, then you could say that I can't see that the burden, I know burdens is a weird thing here, but that there's enough here to see that there's a violation so that we should order under 21.
Yeah, I mean, the only thing is, for questions that are like hard or complicated, while I don't, by and large, feel like things need to go, many of the things that we hear, I feel like they don't need to go before the full task force to get the right outcome.
Yeah.
For really certain hard questions, I do see the value of kicking it to the diverse perspectives.
Yeah.
And it's not just a
Yeah.
legal thing. It's
Yeah.
also like, it's something bigger. It's something, maybe an ethical, social policy thing. So I just bring that up for that reason. And then,
And I think that would be a valid approach in this situation if it were to get kicked, so it goes to that a task force meeting within that 45 days window. And so it goes to the next one.
yeah.
And I know that's, kind of like, whoa, that's fast. Really, that's a totally different world than the way we do things here. And I don't know if it's even possible to do it as fast as the law says we're supposed to do it. But this may be one of the few ways to do it that fast. But I'd have no problem with if two members say, I just don't, I don't want to do a determination today. I don't want to do an order. Let's just kick it to the next task force meeting. Then I think that's the way that one goes. I can see that.
That's fine.
Yeah. And whether we have witnesses actually stand up, talk, that's optional.
Yeah.
I think I put it in here that the parties have to appear. I left that in because I think other people want that. Frankly, I don't know if I necessarily feel like dragging people in. I think they should be able to make a complaint and not have to show up at City Hall in order to do a sunshine complaint. But that's just me. And so I left it in there so that both parties have to be here for that committee meeting. But on the other hand, if some of them might get their answer that day, and we would give them the decision and they don't have to come back a second time.
Right. So that was one question I had. I just wanted to hear what you had to say. And then the other is, this petition notes that it basically severs a 6721B claim from the other claims and can decide it and then continue with the process. Am I correct on that?
I think the way that I think that it was a discretionary thing.
Oh, that you could sever it or not sever it. Okay.
Yeah, if for some reason you get something where there's multiple claims.
Well, because sometimes it's like it's late and this was an improper exemption and whatever it is. It's like things that are kind of tied together, but so if you say, okay, yeah, we agree, it was late and it should have come in. If we haven't decided on whether the exemption was proper or not, it seems like, how do we order that be released?
I would say on that kind, we figure out which of it is a 21 violation. and which of it is something outside of 20. If it's 21, then we're kind of on the clock. And so it's kind of incumbent on us in the committee to try to finalize it, try to finish it. And with the other stuff, we'd have, as it's, two against one or 3 against 0, but we could decide, well, what should we do about this other stuff? But I think that, one of the ways that I'm hoping this can work is that maybe with the other stuff, we could say, well, there's no timeline on that, so let's focus on these 21s. We were told that we got to decide the 21s first, and the other stuff has to wait, and so I think if we are sitting around with nothing to do, then maybe we decide everything at that day. But if we're pressed for time, then we say, okay, we're going to decide the 21 stuff here, but the rest of this case, it gets put back on that non-21, non-priority track.
Right. Which honestly makes sense to me, because the whole thing about getting, I'm just, as I say a million times, like, information has a shelf life. These people need the information when they need it. A lot of times, if it takes a year to get it, it no longer has value to them, really. Like, if they're a reporter who's writing, or if they're someone who's trying to petition to keep their job or stop a tree from being torn down, or whatever it is, a year is like probably too late. And so I understand why you would prioritize, getting people their information on the timeline that the ordinance envisions, and why that should be a priority over, say, saying, okay, this meeting was improperly noticed. That's important, but it's not, there's more riding on someone who's not able to get their information on time. So yeah. And then one other comment I had was that on page 19, last page, where you have the new language that you're adding to Article 6.
Oh, the bylaws.
Yeah, I got confused for a second. So I just want to say, I would put commas around where appropriate, because that threw me. And then I would also put the word make. Where appropriate, make determinations and orders.
Oh.
So committee shall schedule priority review for 6721 claims, including, comma, where appropriate. I guess you could say making determinations and orders.
Appropriate, comma, making. That's fine with me. That's better. That's a good improvement. Yeah. Comma, making. Okay. Yeah, that's fine with me.
So I have,
Just to clarify, that change would come in writing from you?
I will, I think we'll put it on the record, and then I will incorporate it in getting documents that would go to the task force.
so I have 2 questions that may already be clarified, but I want to ask them. Say we make a determination, and what I imagine is the whichever party we made the determination that wasn't in their favor, they say, oh, we didn't want this in front of 3 people. Can we get this in front of the full board?
No.
So
No.
that's
No,
well, I mean, I agree
yeah.
with you. I'm just
Yeah.
saying that's something that I expect. So I'm wondering if that was like addressed in the way this is worded.
It changes our appeals process, right? You can appeal if you have new information or something like that, but you can't otherwise appeal a decision.
Well, there's a reconsideration.
But that's what I mean. That reconsideration you have to show that there was new information that wasn't taken into account
Yeah.
by the
So,
people who made the decision.
so that's the new information avenue. But we don't have anything that's an appeal right now. And I would I would not want to do that because I think that would basically just make this all kind of like
No, yeah.
advisory again.
Yeah, no, I don't want to either. I have no interest in that. I'm just anticipating. I think that the course that you're taking is a good one. I anticipate that.
We would have a lot of people who have a lot of history with this task force would probably be really unhappy about the idea that something doesn't go through the process that exists right now.
Right.
And
It's a handful of people.
a handful
Yeah.
of people, yeah. And that's, I understand that they're going to lose something that they like to have.
Yeah,
They
no,
like to have this feeling like, oh, we're doing the public this service and letting them come in, and have all these hearings and stuff. To me, that's what their view is of what's good and what's important. But my view is different. But we're going to have a lot of people going to say, but everyone should get to go in front of the full task force. And so, yeah, there will be objection on that. And, if you think there's value in that we want to keep, then, we would, that's something that, we could talk about. I don't know if I see any necessity. If you look at the way the law is written, I don't see that there's any necessity that has to happen.
right. Well, for the record, I think that there are a number of issues that come before us that we could make determinations on, and that we end up discussing with the various parties, and then we end up discussing them with the full task force, and that take exponentially longer because there are three of us here, and there are exponentially more of us in the task force, in the full board.
As things are right now.
Yes.
Yeah.
So what I'm saying is I do not think that I'm not suggesting that. I'm suggesting that these parties that you say will be unhappy with it, that they will be, that I anticipate that that's what will happen. They'll be like, why didn't we get a full hearing on this? And the other thing that I brought up at the full meeting about this topic was whether or not there's any mechanism in place for the task force to review the decisions that we've made. Not that I think that it's necessary. I'm just wondering if that's something that is on the table.
That I don't know much about to review the decisions that have been made. How do you-
So again, hypothetically, what I would expect to happen, and when this discussion does come up with the full task force, would be that they would be like, well, what if you're making decisions on this committee that we want to weigh in on, et cetera? What happens then, right? And so like what I had suggested then, and again, this isn't a personal, it's not important if it happens or not, but my suggestion was, if that's the way that you wanted it, that like, well, what if you were able to at least see the decisions that we made, like during a regular course of the meeting, like, and if something flagged to somebody, they could say, we want to bring this up or something like that.
Well, I think that the idea that I have is that this is truly given to the committee that it's assigned to do the 21 determination.
Mm-hmm.
And, if somebody else, like say David Pilpel, just randomly choosing someone who wants to go to our committee meeting and sit in and be involved, that's fine. But if you're not on the committee, you don't get to like have an opinion that matters on something that we decide as a committee. There's not going to be because that's part of the efficiency here.
Yeah.
Is that and to me, like if we are trying to get more efficient, we've got to cut somewhere. And so the idea of adding layers of review or having all these different like kind of people having their say on things, that's where I think we go wrong at this time.
Yeah.
And so I think we need to, even though a committee will make mistakes, we will make mistakes. We'll make bad decisions. Judges, judges at all levels, they make bad decisions. People in government, they make bad decisions. But that's just, there's always going to be that chance of it. But I think this at least puts it before three people. And it gives it a chance of satisfying what, the law tells us we're supposed to be doing. Okay. And so I think that we're basically gambling on, if you give it to three people, that's enough.
Yeah. Well, I mean, I agree with you. I think that I'm not suggesting any change to what your plan is. I'm anticipating that's probably where the biggest pushback will be from the board.
Other people, yeah.
Yeah, is it that they will want to, they'll be like, because that's a significant part of our workload.
Yeah.
On the full board is hearing complaints.
Oh, yeah.
So it's just a matter of like,
yeah,
if you want to address it, not if you want to insert a mechanism, like a review mechanism, just something to keep in mind.
I think you'll still have plenty of complaints here, because right now, like 50% of the complaints are invoke 6721, but there's like 50% that don't.
Yeah.
So those would still go before the full task force. It's not that they're going to be missing those cases. I mean, like not have cases to hear.
Yeah.
But I do wonder about like, are any additional guardrails needed for certain kinds of situations where where it's clear we would send it to the full task force rather than.
But that's to me, even just that default. Oh, well, let's just send it to full task force. To me, I want to know, is that just, I personally, am I just saying to myself, oh, I don't feel like I have the ability to do this? Or am I just like being personally lazy or something like that? I don't think, I understand, I agree with you that we'll get more perspectives if we have 11 people, and then we will with 3. No question about it. But I don't know if the quality of the decision necessarily goes up. The accuracy of the decision goes up very much. If we automatically have everything go to the.
I hear you, but let me give an example.
A hard question.
Yeah, a hard question about jurisdiction. Maybe if there is a discrepancy or a disagreement about jurisdiction, which you can see, like it could even be a checkoff, right? Like is the respondent denying that there's jurisdiction here? Maybe that doesn't even come through a committee ever. It just goes straight to the full task force if there's a disagreement about jurisdiction.
And
I'd like a guardrail.
Yeah.
It's a really important, I'm just giving that, if we think it's a really difficult question, and like why clog it up by sending it to committee first when we know it's just going to go on to the full task force because there's a disagreement about jurisdiction and we don't have, enough info. Maybe I'm saying like something to think about, like, are there certain things that you would just bypass committee, go to full task force, even though it's a 6721 violation claim? And I don't know the answer. I'm just throwing that out as like another.
Yeah, I would maybe put that in the category of like 2.0, like or 3.0 or whatever. Like maybe what I'm trying to do here, this thing that we're sort of on the agenda item for is it's a fairly kind of hopefully compact kind of thing. So it doesn't change anything other than 20 months. And that's, I kind of thought, that might sell better, and it may also mean that people can just focus on, okay, everything else is all just the same, except for this. And yet, all that idea that you just had, I think that's a great idea as a like follow-up idea. And if
You mean as like another,
like,
as an
it's
adjustment
a
later?
different change to the complaint process. And I like the idea of having different ways that these things go, that they're sent, et cetera, et cetera. And like you said, some things where you don't even send it to a committee. That's fun. That sounds good to me. Although I'm trying to keep this where it's not going to become like 11 people debating it and they all have 11 different issues that they're stuck on. And then we end up with, just not really nothing. I'm hoping that at least I can get this one to stick. And then, we could see how this goes. It may be a disaster, but it doesn't have to be a disaster. And I'm hoping that this will shake up other things that may lead us to making other changes. And I'm open to doing some of the other stuff, but I thought that of all the things that we've talked about over, the last year and a half, I thought this gives us the ability to kind of hit at the heart of what we thought was the biggest problem, which is that we have no ability to do really anything here. And the task force people are having to wait 14, 16, 18 months for things. And we as a committee, that's a big, that's like to various extents. I think that's got to be like right on the front of, what's going on here. It's like, why is it taking so long?
And it bloats those meetings too, just to send everything onward to them.
Yeah. And the extra meetings, some of these cases, they show up 5 times and stuff. And I just don't know how much that really is of value to anyone.
I do think that it's appropriately narrow. It's just more like the only thing is like just how to make sure it's palatable that it passes. So like, I think that like in terms of guardrails, I thought of like just 2 things. One is, have we discussed an evaluation period? Like how long are we doing this before we report back on how it's going or anything like that to the board?
I think that we could say, if people wanted that, I have no problem with doing something like that, like a year down the road, see how it's going, or 6 months. I didn't write in anything about like how to do that. I guess that would have been sort of some layers on that I didn't want to add in there. And but I have no objection to something like that, to putting something like that in there. And we could do something like that, or we could like, if say we were to pass something today forward to the task force, we could say, well, we're going to pass this with a couple of changes, and we are considering having a review period. That's I
actually think
something like that.
Actually, that probably makes the most sense. The other one that I had, I don't think. I mean, it's not as necessary. I just thought the only one I thought the idea was like, well, what if it wasn't a unanimous decision? Like, what maybe those could be up for some sort of, if we wanted to push that forward. If it was like 2-1 or 3-1 or something. But it wasn't as, I'm not even that sold on it. It was just an idea.
Yeah, I understand what you mean. That's a different ballgame.
Yeah. But I do think that I think that might help,
Yeah.
like make it something passable for the board.
with the review period?
Yeah, I
Okay.
think so.
Yeah, let's say, how about we just say with a 1-year review period? Is that, how does that,
So you would want to include it in the annual report for 2025, basically, as I'm guessing.
You could just review it like as a agenda item.
Okay.
with a full task force after 6 months or
Yeah.
something like that. That's kind of what we've done with some of the other changes that we saw, like when member neighbors
yeah,
instituted that, like, form that we wanted respondents to fill out. We had in there that we would review it after 3 months or 6 months, like, and see, like, is it working? Are people using it? Is it helpful? All that stuff.
yeah, we just sort of say, well, what do people think? How's it going? Does anyone have anything concrete in terms of numbers, et cetera? And if enough people say, well, this is out of control, this just is not working at all, or else it's a waste of time, or else we're not complying with it, et cetera, et cetera. But yeah, we would sort of put it on the calendar for, say, it could be 6 months, could be a year. I'm just throwing out a year as at least that gives us a sort of like a track record to look at as 1 year.
I'm not picky about the timeline.
Okay.
Just the idea is a good idea, I think.
Okay. Yeah, I say, okay, 1 year from passage.
I just want to say, you might want to look at, just in thinking about, like, if there needs to be any specific type of guardrail or objection or, about like what might get complicated here, looking at the complaint resolution data for 2023 that I posted, because it has all the alleged violations for every case there. So you can just kind of go through and see, like, oh, how many were just alleging 6721 alone? How many were alleging 6721 in conjunction with other violations? There are an awful lot that are 6721s plus 6725, the IDR, where those kind of, putting it together, or the Pop G calendar with the 6721. But then there are also like sort of subclass of combined allegations of violations that get into issues of, is this really public information that needs to be disclosed? Is this properly exempted? And then a bunch that are just there with allegations that this wasn't minimal withholding, was this level of withholding proper?
Yeah.
And was the way the withholding was explained proper? Those seem to be like what we get most often in combination with the 6721. So if there's anything in there that you feel like, oh, this is going to be, so that question about, like, is this really public information might be one. I don't know, but it might be helpful just to see, what are the ways that what does this come up with? And is there going to be any problem in any of these kind of pairings of, issues that we might want to address? I don't know. But there's an awful lot.
Just to clarify, on those cases where you have 21, but you also have other things, I think what the way I wrote it was that, yeah, we do the fast 21. That's 21's in the priority category. The other stuff, we can choose to just say, sorry, we don't have time. Or we can say, oh, yeah, we're going to use the old process to make our recommendations and send it to the full task force. And so we've got those two as options for the non-21 stuff. I think if something is sort of like,
So we might send it and say, this is late. We decided, yes, this is definitely late, but now you, full task force, decide, was this public information, or pieces of this public information, or
if it's something that's outside of 21, if it's, I mean, we could do something, if it's, I think the 20, well, if we don't, you're saying public information under 21 or
no,
under
we'll
one of the other statutes?
Yes, under 24.
Under 24, okay. I think that a 24 determination, the way I would try to answer your question is to say, Well, there's no 45-day period. There's no 45 there. So that's not really what this is about. Now, if the 6724 determination was so tied up with the 21 that you just said, well, let's decide that too, because we're here anyway. Then I'd say we could recommend something to the task force, make a recommendation and send it on. But I wouldn't feel like that's the kind of thing that we're changing the process on at all.
Okay.
Okay.
Yeah, I would just make that clear somehow in the proposal that it opens up the possibility to decide 6721 cases, and other sections that might be, affiliated with that decision where possible. But if not possible, it would be sent to the full task force.
Yeah, I think, let me just look.
I mean, if that's what you think, I don't
Real
know.
quickly.
Things where I.
No, it makes sense. Yeah, in my write-up on page 6, footnote 5, I said this proposal would leave in place the existing process for resolving non-21 complaints.
Right.
Public meetings violations, IDRs, 67.295 calendars. So I guess it's in a footnote. So, but that's definitely in my intent, is that only the 21s are absolutely on this new fast track. And anything else, because it doesn't have to be decided in 45 days, it stays kind of as is.
So I'm just picturing this. So say someone comes and they say there was a violation of 6721 and a violation of the Prop G calendar. And we look at it and we say, yeah, this was definitely later than it should have been for the class of information that was decided.
Yeah.
We can decide both on the 6721 and on the Prop G calendar there.
Not a final.
Yeah, you can just move the calendar forward.
We push that one forward.
So, but when it goes forward, they're not making a separate 6721 thing.
Yeah.
They're just late. We're telling them you have to release this information, which happens to be a Prop G calendar information, but we're not finding the violation of the Prop G until it goes to the full task force.
Yeah.
Okay.
Yeah. Which sounds like a little bit odd.
Yeah.
But that's because the law puts those on different footings, and we could take this and rewrite it to say, well, we're going to also decide calendar stuff. I'm not going to do that now, but it could be that other things should be going faster and should be decided in this committee in addition to 21 stuff. I would not object to that. I would not object to that myself. Especially like those calendar cases, they're easy.
They're the
We could
easiest
decide
one.
those.
But I agree to keep it narrow though.
Yeah, but that's, I figure, there's like 11 members and anybody can propose any changes they want. And I encourage, anyone to make changes. I'm just trying to hopefully get one thing changed.
Yeah.
We'll see if that happens.
I mean, I like this proposal. I would be in favor of it. I'm just thinking about like the situations where it seems like slightly awkward. Like, okay, so we say this is 6721, but we're still waiting on the official 6725 violation, but we've said this is late, you need to give it. So I guess that starts the ball rolling on getting the information.
They get in order.
Not all the violations have been just, found.
I mean, I think it might change how people file too.
It could, yeah. Tricia, were you gonna say something?
Really just wants their Prop G thing to go in front of the full task.
Or they just want something,
That 6721
yeah.
maybe.
Or they'll just file the 6721 if they just want violation.
It's still gonna go twice. If they file 6721 and 6725, they're still going to go before the committee and the task force. It's just the different components are going to be decided at different levels.
Yeah,
I still think that that's,
yeah.
I think that's the best way to get it passed as well, though. Like to literally only focus on the one thing, and then to see how that goes, and then to add Prop G if
Yeah.
that goes well.
Yeah, we add things in later.
Yeah, because I agree with you. It's inefficient, but it makes it actually does make sense.
No more inefficient than today.
Yes.
And it might be more efficient still because you'll only be discussing one.
Right, you're focusing it. Maybe.
I at the last meeting, Chris actually walked over to me and said, I heard you're gonna change things. What the hell are you? Where are you on that? Because I'm gonna vote for it. So I figure we're at least partly on the way to 6.
Yeah.
Yeah.
But I mean, overall, I think, yeah, let's try this.
Okay.
Because I don't see it making anything worse.
Mhm.
And I think it could make things substantially better in terms of improving the timeline of how these cases are processed.
I think there's some flexibility in certain areas where it'll feel like, that's a weird twist on things. How do we handle that? There's enough that I think it can be dealt with, as it comes along. Okay. Well, I've got the notes on comma, where appropriate, comma, making 1-year review period. Those will be, I will make sure that those are somehow notated so that it's clear that those are part of what we passed today. And then we will, I'll make a motion that we approve as a committee this proposal, and we send it to the full task force.
I'm sorry, one more time.
A motion that we approve as a committee this proposal, item 10, and we send it to the full task force for review and approval.
The motion is to approve this item approve as a committee this proposal and send it to the full task force for review and approval. Yes?
Yeah.
Okay. Second?
I second.
Seconded by Member Sugarman. Public comment. We have no one in the room and there are no callers in the queue.
Okay, so let's vote.
Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. 3 ayes. The motion passes.
All right. Good. Excellent. Thank you.
Item 11.
Yeah.
Announcements, comments, questions, and future agenda items by members of the Complaint Committee.
No, nothing. Nothing.
Actually, I have a question. Did we ever hear from the new member about whether they're joining the complaint committee?
No, although it was sort of ragged there at the last hearing because she didn't even get to hear what the committees do, and she came in an hour and a half late. Yeah, so we could yeah. I asked Maxine if she wanted to be on this committee. And then Kumar and Anita, is it no, why am I thinking that? I don't know her first name. Maxine said no, but she had some reason. And so I asked Ms. Kumar if she would be on the committee. And part of the reason was that I thought that could take some burden off of you, as since you're the vice chair too. So I don't know how much effort that is to do, but we could simply have 4 on the committee. And then we could, sometimes someone wouldn't show up and we'd still have 3 for the committee. And I thought that, plus they're not on a committee, so I suggested that, but I haven't heard anything.
That's yours.
Okay, next item.
Okay, no action on item 11. Item 12 is adjournment.
Move to adjourn.
Adjourned at 9:30 p.m.
Last time I